Good morning. Today's legislative hearing is going to focus on three bills, two bipartisan bills addressing LNG exports introduced by Mr. Johnson and a bill introduced by Mr. Wahlberg to modernize the Public Utility Regulatory Policies Act of 78, also called PURPA. I want to thank our witnesses for appearing before us today to give their views so that we can work to perfect these bills. On the first panel, we're going to hear testimony from the Department of Energy on two LNG bills, H.R. 4605, the Unlocking Our Domestic LNG Potential Act, and H.R. 4606, the Ensuring Small-Scale LNG Certainty and Access Act. And we'll also receive testimony from Ferc on H.R. 4476, the PURPA Modernization Act. We also have a second panel of witnesses today so we can hear from industry and state regulators to better understand the impact of the legislation. As we consider this legislation, I'm reflecting on our bipartisan codel to Puerto Rico and the Virgin Islands last month. It is hard to put into words the devastation and loss, and it's hard to fathom that it has been more than 100 days since the hurricane struck, and yet hundreds of thousands of folks are still without power. As we learned on our trip, Puerto Rico's grid was in a very rough shape to begin with, and many of their power plants were so outdated they were still burning petroleum. I believe there is a real potential for Puerto Rico to expand their use of natural gas, and these bills, especially the small-scale LNG bill, can be part of that solution. So I think I speak for all those who join with me on the codel when I say that we're going to continue to stay focused to ensure that the territories and the people receive the assistance that they deservedly need. With that, I'd like to thank this panel of distinguished witnesses for appearing today. I look forward to your testimony, and I was going to yield to Mr. Wahlberg for a minute or so. Mr. Wahlberg.
Mr. Chairman, thank you for holding this hearing today. I want to also thank your staff for being a part of this process. They've been terrific to work with. I would like to quickly point out that this legislation that aims to bring a 40-year-old law into the 21st century is an important aspect to deal with. It is time that my constituents see the advancements made in the electricity sector reflected in their utility bill. H.R. 4476 aims to lower electricity bills for American families to stop the gaming of a federal law at the expense of my constituents. I'm willing to work with all interested stakeholders moving forward to make changes to this legislation to ensure we bring real benefits to hardworking Michiganders and others all around the United States. I look forward to this hearing and yield back my time.
Coming yield back, I yield now to the ranking member of the Energy Subcommittee, Mr. Rush.
Thank you, Mr. Chairman. Today we will be examining legislation addressing LNG exports and PURPA modernization. I must say, Mr. Chairman, that at the outset, I do have concerns with all three bills that are before us today. It is my hope that the majority will work with our side to address each of these issues as we move through the committee process. To begin with, Mr. Chairman, H.R. 4476 would make sweeping changes to PURPA, changes, Mr. Chairman, that will fundamentally alter both its objective and its effectiveness. For the past 40 years, this policy has helped to promote wholesale distribution of electric energy while increasing energy efficiency and ensuring that energy consumers receive fair retail rates. PURPA's effectiveness, Mr. Chairman, has come from its unique role in facilitating competition in the electricity sector, and I am concerned that some of the proposed changes under H.R. 4476 will hamper the law's ability to achieve its original objective. Specifically, Section 4 of H.R. 4476 would essentially strip away purpose requirements that utilities must purchase from certain qualifying renewable energy projects, small power production, and cogeneration facilities. As you know, Mr. Chairman, under current law, there is already an exemption from the must-buy provision if FERC determines that a qualifying facility has non-discriminatory access to specific market-related conditions. However, H.R. 4476 will give certain utilities the ability to refuse to purchase energy from small power producers or provide services to a QF if that utility determines that it has no need to purchase such power, or the utility procures long-term generation resources through a competitive process and uses integrated resource planning, or RRPs. Mr. Chairman, H.R. 4476 provides little to no insight for non-regulated electric utilities or for those operating in states that do not require RFPs. My concern is that the changes in H.R. 4476 will replace a system that currently works well in ensuring competitive environment, a competitive environment for smaller, privately owned energy producers, with one that severely reduces competition. Mr. Chairman, and if it ain't broke, it don't need a fix. Additionally, I also have concerns regarding both H.R. 4605 and H.R. 4606, both of which address the exportation of LNG, and neither of which is really, in the final analysis, necessary. While H.R. 4506 to be some sort of a sweetheart deal, my issues with H.R. 4605 surround this elimination of the section prohibiting the import or export of natural gas without prior DOE approval, while also removing long-standing consumer protection. So, Mr. Chairman, I look forward to today's hearing, and I look forward to concentrated and very robust discussion around these important issues. And with that, I yield back the balance of my time.
Gentleman yields back. Chair would recognize the chair of the full committee, gentleman from Oregon, Mr. Walden.
Thank the gentleman from Michigan. I welcome our witnesses. Today, the committee will examine legislation to encourage and streamline the process for approving liquefied natural gas exports and modernize the Public Utility Regulatory Policies Act of 1978, also known as PURPA. For some of us, 1978 doesn't seem that far back. For others, it may seem like ancient history. Under my chairmanship, I've encouraged our members to put consumers first and focus on ways to grow our economy. To do this effectively, we need to look to see where we can update our laws and regulatory policies for the 21st century. I want to thank Mr. Johnson and Mr. Wahlberg for their hard work on these bipartisan bills, and I'd also like to thank the witnesses for appearing before us today and providing their views on these two important pieces of legislation. You know, the United States is the world's #1 producer of oil and gas, and our reserves are so large they're predicted to meet domestic demand for a century or more. Who would have thought? Up until the shale revolution, our supplies were dwindling. We were importing natural gas. As you would expect, our laws reflected that reality. However, we're in a completely different situation today, and for the first time ever, we're net exporters of natural gas. Now, to capitalize on this incredible opportunity, we need to update our laws to remove unnecessary barriers to innovation and growth. As dozens of studies have shown, including those sponsored by the Department of Energy, LNG exports provide wide-ranging net benefits to consumers and the economy. Mr. Johnson's legislation would remove unnecessary restrictions on these exports, which date back to the 1930s. These changes would help create more open, transparent, and competitive markets for natural gas, encourage more production in the U.S., create thousands of jobs, and spur further economic development. All good things for America. It should not be overlooked that LNG exports also strengthen our diplomatic hand when dealing with countries like Russia that like to use their energy resources as weapons. Encouraging the use of clean-burning natural gas around the world also helps to reduce greenhouse gas emissions and improve the environment. Exports are truly a win-win for all sides in America. Today, we're also examining legislation to modernize PURPA. This is a law that was enacted to encourage the use of domestic energy in response to the Arab oil embargo. Since PURPA's passage, the nation's power sector has undergone remarkable changes in ways that electricity is supplied to consumers. So Mr. Wahlberg's legislation recognizes these changes and updates a 40-year-old law to ensure that it serves the interest of consumers and power suppliers for years to come. Now, most notably, the PURPA Modernization Bill will address the concern that certain facility developers are successfully evading the intent of Ferc's 1 mile rule. At last year's oversight hearing on PURPA, we heard examples of project developers building power-producing facilities just far enough from each other so they could avoid PURPA's 80 megawatt threshold, thus allowing them to receive the benefits that are intended for small power producers. H.R. 4476 offers a specific fix to address this concern, and I'll be interested to hear Ferc's thoughts on this issue today. As I've said before, the Energy and Commerce Committee strives to focus on the needs and interests of Americans' consumers. We are putting them first. With that, I look forward to our witnesses' testimony and discussion among the committee members on the proposals to revise the LNG policies and to modernize PURPA for the 21st century. With that, Mr. Chairman, delighted you're chairing this hearing. Look forward to the testimony as we move this legislation forward, and I yield back the balance of my time.
Gentleman yields back. The chair will recognize the ranking member of the full committee, Mr. Pallone, for an opening statement.
Thank you, Mr. Chairman. Today we will be examining legislation addressing natural gas exports and changes to the Public Utilities Regulatory Policies Act, or PURPA. While I'm pleased we're taking the time to examine these bills, I fail to see the need for almost any of the policy changes that they propose. First, we have H.R. 4605, the Unlocking Our Domestic LNG Potential Act. The bill does away with the Natural Gas Act's prohibition on the import or export of natural gas without prior approval from the Department of Energy. It removes longstanding consumer protections and prevents DOE from ensuring exports of liquefied natural gas to non-free trade agreement countries are consistent with the public interest. As a result, the public would not have an opportunity to know about or provide input on natural gas exports to any country at any level. Furthermore, we must have a mechanism for the federal government to know the source and destination of gas imports and exports, something that is critical for our national security. DOE's process for reviewing and approving gas export applications is working efficiently and effectively, so I fail to see a reason to alter it, let alone do away with it completely as proposed by this bill. I'm particularly concerned that the unrestricted export policy included in this bill could significantly impact domestic natural gas prices and adversely affect American consumers and manufacturers. Furthermore, unfettered exports could be even worse for climate change. The policy incentivizes widespread fossil fuel extraction with virtually no environmental protections, adds more fossil fuels to the electricity mix rather than replacing dirtier sources, and artificially props up the coal industry. H.R. 4606 appears to be an attempt to codify the Trump administration's recently proposed rule to expedite the approval of small-scale natural gas exports, and that rule would deem certain lower volume exports to non-FTA countries in the public interest, so long as DOE's approval of the application does not require an environmental review under the National Environmental Policy Act. And I have concerns about this rule, but it's a model of restraint compared to this legislation, which would keep DOE's volume limit but completely jettison the requirement that applications qualify for a categorical exclusion from NEPA. It speaks volumes that this bill has even fewer environmental safeguards than a Trump administration proposal. The bill also fails to prevent applicants from using this new process to evade the public interest determinations required for large-scale exports by segmenting a large volume gas export into a series of smaller proposals. Mr. Chairman, perhaps even more troubling is that according to the Congressional Research Service, only one project currently meets the capacity requirements of the administration's small-scale LNG rule, but does not qualify for a categorical exclusion, and that's a project in development by Eagle LNG Partners in Jacksonville, Florida. Since the bill does not include a categorical exclusion provision, the Jacksonville facility would be the only project to benefit from this new expedited process. That sounds to me suspiciously like the kind of legislative earmark that I thought my Republican colleagues opposed, and I look forward to hearing my colleagues' views on that matter and why this bill is even necessary at all. And finally, there's H.R. 4476, the PURPA Modernization Act of 2017, which significantly alters Section 210 of PURPA. This provision has long ensured beneficial competition for generating resources, save consumers money, and further the growth of renewables and cogeneration. This committee, under the leadership of former Chairman Barton, struck the right balance when it significantly updated PURPA in the Energy Policy Act of 2005. In contrast, this bill lacks that balance, with two of the three main components of H.R. 4476 representing a direct assault on PURPA that would solidify the monopoly power of utilities in areas without competitive wholesale or retail markets. And having said that, I am not completely opposed to updating PURPA. The part of Mr. Warburg's bill dealing with the so-called 1 mile rule, which many claim has encouraged the segmentation of PURPA projects that would otherwise not qualify under the law, that merits attention. Is certainly a topic that we'd be willing to try to address in a bipartisan fashion, but overall, these bills really are not in the public interest. So I thank you, and I yield back the balance of my time, Mr. Chairman.
Gentleman yields back. We're now prepared to hear the testimony from our first panel. We're joined by first Stephen Winberg, Assistant Secretary for Fossil Energy from the Department of Energy, and then Mr. James Stanley, General Counsel from Ferc. So thank you. Your testimony is made part of the record, and we'd like to give you 5 minutes now to summarize that, and then we'll go into questions. Mr. Winberg, welcome to the subcommittee.
Chairman Upton, Ranking Member Rush, and members of the subcommittee, it is an honor to appear before you on behalf of the administration. I will provide technical comments on the two bills that pertain to the Department's authority under the Natural Gas Act to regulate natural gas exports. DOE's authority to regulate the export of natural gas arises under Section 3 of the Natural Gas Act. This authority is vested in the Secretary of Energy and has been delegated to the Assistant Secretary for Fossil Energy. Section 3A of the Natural Gas Act sets forth the standard for revision of most LNG export applications. The Department interprets Section 3A as creating a rebuttable presumption that a proposed export of natural gas is in the public interest. Under this provision, DOE performs a thorough public interest analysis before acting on applications to export natural gas to non-free trade agreement countries. In the Energy Policy Act of 1992, Congress introduced Section 3C to the NGA, which created a different standard for free trade agreement countries that deems these applications to be consistent with the public interest and granted without modification or delay. Since January 2017, DOE has granted authority to export natural gas to two world-scale LNG projects, Golden Pass Products in Texas and Delfina LNG, which is proposed for offshore Louisiana. DOE has also granted authority to export to Eagle LNG's small-scale Maxville, Florida project, as well as an additional capacity at the proposed Lake Charles LNG project. In total, DOE has authorized 21.35 billion cubic feet per day of natural gas under Section 3A for export to anywhere in the world not prohibited by U.S. law or policy. This morning, I will provide technical comments on both H.R. 4605, the Unlocking Our Domestic LNG Potential Act, and H.R. 4606, the Ensuring Small-Scale LNG Certainty and Access Act. In 4605, H.R. 4605 would remove DOE's authority in regulating natural gas trade for the United States. Currently, under the NGA, DOE has authority over imports and exports of natural gas. The Federal Energy Regulatory Commission has authority over the siting, construction, and operation of interstate natural gas pipelines and LNG terminals. The bill appears to make no modification to FERC's jurisdiction under the NGA. Under current law, LNG export project sponsors submit applications to both FERC and DOE, and most projects require the completion of an environmental impact statement under the provisions of the National Environmental Policy Act. In these cases, FERC is the lead agency in preparing the EIS, and DOE is the cooperating agency. Separate from the FERC reviews, DOE conducts a public interest review under Section 3A of the Natural Gas Act. Regarding H.R. 4606, all exports of natural gas, regardless of quantity, are subject to review and approval by DOE through its regulatory authority under the Natural Gas Act. H.R. 4606, regarding 4606, all exports of natural gas regardless of quantity are subject to review and approval by DOE under its regulatory authority under the Natural Gas Act. H.R. 4606 would amend Section 3C to expedite approval of imports and exports of small volumes of natural gas. The effect of this bill would be to have qualifying applications granted without modification or delay. This bill appears to be similar to the volume criteria DOE laid out in its recent DOE Notice of Proposed Rulemaking concerning small-scale natural gas exports, published on September 1st of 2017, which offered that natural gas export applications to non-free trade agreement countries that propose to export up to and including 0.14 billion cubic feet per day would be deemed to be consistent with the public interest. So in conclusion, I note that the United States has become the world's largest combined producer of oil and natural gas, resulting in an abundance of reliable and affordable energy resources. In 2017, the United States was a net exporter of natural gas for the first time on an annual basis since 1957. Overall, the Energy Information Administration forecasts net natural gas exports to average 2.3 billion cubic feet per day in 2018 and 4.6 billion cubic feet in 2019. The Department appreciates the ongoing bipartisan efforts to address our nation's energy challenges, looks forward to working with the committee on the legislation on today's agendas and on any future legislation. Thank you for the opportunity to be here today, and I look forward to your questions.
Thank you. Mr. Stanley, welcome to the subcommittee.
Mr. Chairman, Ranking Member Rush, members of the subcommittee, I appreciate the opportunity to come here and testify today. My name is James Stanley, and I'm the General Counsel of the Federal Energy Regulatory Commission. Before I begin with my opening remarks, I want to mention that I'm appearing here today as a staff witness, and my opinions are not those of the Commission or of any individual commissioner. I've been asked to testify about a bill that amends the Public Utility Regulatory Policies Act of 1978, PURPA. That bill, H.R. 4476, has three provisions in it, and I'll briefly discuss the effect of each one in turn. The first of the provisions, Section 2, has to do with the so-called 1 mile rule. PURPA defines small power production facilities as any power production facility which, when taken with the other facilities at the same site, that determination is made by FERC, is less than 80 megawatts. And it's worth pausing for a second to mention that the small power production facility is one of the two types of qualifying facilities under PURPA, the other being combined heat and power cogeneration. The regulations that were promulgated by FERC pursuant to PURPA provide that generation facilities are considered to be at the same site if they are within 1 mile of each other, if they share the same energy resource, and if they're owned by the same person or an affiliate of that person. The proposed bill would convert the Commission's current bright line 1 mile rule to a rebuttable presumption that could be overcome by a number of specified statutory factors. For example, were the facilities that are more than 1 mile apart purchased with the same financing, or do they share an interconnection point, such factors like that. The second provision, which is Section 3 of H.R. 4476, has to do with non-discriminatory access. The heart of PURPA is the mandatory purchase obligation. That's the mechanism that really drives PURPA's effect. This provision requires utilities to purchase the electric power of the qualifying facilities that operate within their service territory. This is regardless of whether or not the utility requires that power and whether or not the QF participated in the procurement process of that utility. Under PURPA, the power is to be purchased from those QFs on a mandatory basis at the avoided cost rate that's established by the state instrumentality responsible for regulating those utilities. In recognition of the changing landscape of the American power industry, in 2005, Congress passed EPAC 2005, which had a provision that allowed for the termination of this mandatory purchase obligation when the Commission makes a finding that a QF enjoys non-discriminatory access to an electric market. In implementing that provision of EPAC 2005, FERC promulgated regulations which established a threshold of 20 megawatts, above which it would be rebuttably presumed that the QF did have non-discriminatory access to the market, and below which there was a rebuttable presumption that it did not. This was based on the basic premise that the larger the QF's capacity, the more likely it is to be a sophisticated party, and the more likely it would have non-discriminatory access. The proposed bill leaves the basic mechanics of this threshold in place, simply lowers the threshold from 20 megawatts down to 2.5. And then the last provision, Section 4 of 4476, has to do with the state and local determinations of need. As I explained a moment ago, the heart of PURPA is that mandatory purchase obligation, and it's fundamental to the way PURPA works currently. In response to the 1970s energy crisis, PURPA was passed in order to establish a nationwide policy which is explicitly stated in the statute to encourage the development of cogeneration and small power production facilities. That policy objective was largely achieved by this mandatory purchase obligation, and as drafted, the bill would alter PURPA so as to replace the nationwide policy advancing those interests through the mandatory purchase obligation to a state-by-state regime that would allow state agencies to relieve their utilities of the obligation to mandatorily purchase power from qualifying facilities if the state agency certifies to FERC either that there is no need for their regulated utilities to purchase the power that the QFs produce, or that the utility employs some type of a competitive procurement process. This represents a fundamental change to the mechanism of how PURPA operates, and as such, as the agency that is charged with implementing PURPA, the subcommittee and Congress are in a far better position to determine whether or not that advances the policy goals of PURPA. With that, I have no more remarks to start with. I'd just like to thank you all for the opportunity to give my thoughts on these bills, and I look forward to your questions.
Well, thank you very much. Mr. Stanley, back in 2015, Senator Murkowski and I wrote to FERC regarding the state of PURPA in the face of changes that the electricity markets have undergone in the last number of years. And in that letter, we asked FERC to take a comprehensive look at PURPA and its regulations. And I know that you held a one-day conference to discuss those concerns. Can you tell us what FERC has been doing to update the regs and policies since that letter went?
Certainly, yes. The Commission has kept PURPA in mind for years. It's one of the main statutes we administrate. And the technical conference was convened after the presentations and submissions in the technical conference were reviewed by staff. Further comments were solicited on a number of questions that were thought would be valuable to amplify the positions of the people who appeared and submitted the initial round of comments. Those were received, I believe, in November of 2017 or thereabouts, and the issue is still pending before the Commission today for consideration.
Do you have some guess as to when they'll come to a conclusion or make some finding to go forward?
I do not know when that will happen. It is certainly one of the subjects that the Commission has actively pursuing.
Mr. Winberg, we are all grateful that the U.S. is now the largest producer and exporter of LNG. A number of us on this panel have gone places overseas to look at the need and the requests for additional LNG exports to those countries. In the past, there's been a pretty big backlog of requests by companies be able to export LNG. Can you tell us what that list may look like today in terms of requests for approvals by the Department of Energy?
Yes, thank you, Chairman Upton. We have, there's actually 54 applications that have been filed. There are 29 that have gone through final approval, and there is one that is conditionally approved. So out of the remaining 24, they're in various stages of approval process. A lot of them are going through the NEPA process, which I'm sure as you know can be a very lengthy process. So that's the status. I can tell you that in 2017, there were 3 that were approved. Golden Pass, that I mentioned in my testimony, Delphin, and then Lake Charles. That was an amendment to an existing one, and then the Eagle Maxville LNG, which is the small-scale facility.
And as I recall, each of these projects, as they go forward, if they're approved, could mean as much as $100 million in terms of infrastructure construction. Is that still about the right number, the dollar amount?
I think that's probably a good number, and a fair amount of investment needed to get through the NEPA process, because you have to do a front-end engineering and design study, and that's quite expensive as well. So, yes.
Well, as these, I'd just like to say that as these two bills begin to move forward through the process, we look forward to your engagement and commitment to work with us to help us make improvements to that legislation.
Happy to do so.
With that, I'll yield to the ranking member of the subcommittee, Mr. Rush.
I want to thank you, Mr. Chairman. Mr. Stanley, I really want you to clear up something for me. I'm somewhat confused in terms of your opening statement. Are you here to as a witness for the for Ferc, or are you a witness for the staff?
I'm sorry, I didn't understand the question. Could you say it again?
All right. You said in your opening statement that you were not representing the commissioners, but you were representing the staff.
Yes,
I
that's
just
correct.
want to explain that to me.
I am the general counsel. I am not one of the commissioners. The commission is a multi-member independent agency. The commission, as an agency, can only speak through its orders, which are issued by the votes of the commissioners. I am not only unable to predict what they're going to do at a specific time, I'm actually restricted by our regulations from making predictions about what they're going to do and when.
All right, Mr. Chairman, is that sufficient for this committee?
Yeah. We'd like you to help us with the Senate. Are you able to do that?
I'm happy to try.
All right. Thank you, Mr. Chairman. All right, Mr. Downey, in your testimony, you noted that H.R. 4605 would delete Section 3A of the Natural Gas Act, which includes a public interest standard for judging whether or not to approve LNG terminals. What is the significance of omitting the public interest determination? And why do you suggest that this committee should consider reintroducing such a standard as this bill moves through the committee process?
Thank you for the question. I offered that thought in my testimony for really only one purpose. Because it appeared to me that the purpose of the two bills was to make alterations to what was squarely within the DOE's jurisdiction, I thought that perhaps there was an unintended consequence of removing that public interest standard on the basis of which FERC is charged with overseeing the siting, construction, and operation of LNG terminals. And I wouldn't want the committee to unintentionally remove the public interest standard that applies to FERC's role in LNG terminal approvals as opposed to the DOE's.
Mr. Weinberg, under current law, DOE is responsible for conducting the public interest review under Section 3A of the Natural Gas Act. So I'd like to hear from you your thoughts on the significance of gutting this section.
Thank you for the question. The administration hasn't taken a position on either of these bills. apologies. The administration has not taken a position on either of these bills. Congress gave authority to the Department of Energy to perform the public interest review. We certainly look forward to working with this committee to review the bills in more detail and to understand the implications that they have. But ultimately,
I certainly want to thank, my time is running out. I think I'm pretty clear. I want to ask Mr. Stanley and yourself, Mr. Winberg, does Ferc or DOE have any concerns over hastily approving significant amounts of LNG for export and how that might impact prices for domestic gas, natural gas customers, our manufacturing competitiveness, or jobs here in the U.S.? After all, we already just witnessed natural gas price spikes during the most recent cold snap. Are either of you concerned about unintended consequences if we start basically approving any and all requests for LNG exports willy-nilly or without a public interest review?
I can give a very quick answer. FERC does not have anything to do with the public interest analysis for exports, and I don't have any opinions on the subject.
To date, DOE has approved just a little over 21 BCF per day for LNG exports. Currently, there's only about 3 billion cubic feet per day being exported. So there's plenty of room within the what's been authorized and how much we're exporting. And the studies that we have done, the most recent studies suggest that we could have exports up to 28 billion cubic feet per day with no negative economic benefits or no detriment to the price of gas in the United States or our economy. To your point on the recent deep freeze, bomb cyclone, and the high prices, I would suggest to you that that's probably more a function of inadequate pipelines than it is the resource base. The price of natural gas in Dominion South and down in Texas went up slightly. The price in New England, of course, was up at about $150, and that spread was mostly due to inability to get gas up into the Northeast during that deep freeze.
You're back, Mr. Chairman.
Thank you. Mr. Walden.
Thank you very much, Mr. Chairman. Again, thanks to our witnesses for your testimony today. Mr. Stanley, as you know, QF developers can skirt the intent of FERC's 1 mile rule by breaking a large project into smaller projects to bypass the FERC's size limitation. H.R. 4476 directs FERC to investigate a list of factors if somebody challenges a QF developer's application. My question is, can FERC implement these changes to the 1 mile rule without H.R. 4476 becoming law?
Yes, that is something that we can pass regulation, we can promulgate a regulation for.
Well, that would appear to be a pretty easy fix for FERC to make to its regulations. I don't know if you can answer this or not, but is that something FERC has on its mind to do?
I do not know what the commissioners have on their mind. I know that.
Do you know what they have on their agenda?
I do know what they have on their agenda.
Is this on their agenda?
And among other comments that were submitted both orally and in writing to our tech conference, suggestions along the lines of the provisions of H.R. 4476 were included. It's under active consideration among all the other comments at the.
So you're limited on what you can predict.
Yes.
Got it. Mr. Wimberg, in 2010 and 2012, the Obama administration Department of Energy commissioned studies on the macroeconomic impacts of LNG exports. The major findings in the LNG exports would benefit the entire economy, not just the oil and gas producers. Could you walk me through some of those findings and answer this question? Does the Department of Energy plan on updating the study, since the last one appears to be from 2012?
At this point, we don't have immediate plans to update the study. As I mentioned, the last macroeconomic analysis that we did, we evaluated 28 billion cubic feet per day as a number that we could live underneath that umbrella. I also mentioned earlier, I believe that currently we're only exporting 3 billion cubic feet per day, so there's a good deal of headroom between
Okay.
where we are and where we think we can go, and still provide a lot of economic value to the country through construction jobs and operation maintenance jobs on these LNG facilities. I do not have any specific numbers for you relative to the economic impact. I'm happy to get those for you, though.
Yeah, I think that would be helpful. You know, it's a big debate out there about the importance and effects of LNG exports and jobs and effect on greenhouse gas emissions. Can you talk at all about what happens when it leaves the country and kind of the fuel switching that may or may not take place, where it goes? LNG?
That's a big part of, or a component of our public interest review to understand where the LNG is going. Having come out of the natural gas business, and especially in seaborne trade, I can tell you it becomes very difficult to start chasing molecules that are in ships. It's just the way the seaborne trade operates, so it isn't easy to track those molecules necessarily. However, on LNG tankers, if they're going from port to port, we know where the
Right.
fuel's being delivered, but at any point in time, some of those tankers can be diverted.
Okay, all right. I guess that's all I have. Mr. Chairman, I yield back.
Mr. McNerney.
Well, I thank the chair and I thank the witnesses. Mr. Danley, what forms of generation is 4476 aimed at specifically?
Do you mean which category of QF? That's the small power production facilities.
Well, I mean, are they aimed at wind or?
The types of power production facilities that can qualify as a QF under that part of the regime are renewables, waste, facilities powered by waste, and
What would be the most impacted? What form of generation would be the most impacted?
I would think probably renewables would be, but I'm not certain. I haven't thought about that specifically, but that seems to be logical.
Well, does HR 4606 benefit more than one corporation?
I'm sorry, 4606 or 4476?
4606. I've changed the subject.
Oh, okay. I'm sorry. Apologies.
Sorry.
Could you say that good question again, because that threw me?
Does that benefit more than one corporation?
I don't know. I would presume. You know what? I do not know the answer to that. I can't tell you. I'm sorry.
Do you have an answer, Mr. Winberg?
I think 4606, as I understand it, is intended to allow expedited permitting of small export and import facilities. As was noted earlier, there's only one right now, but that's not to say that there won't be more applications.
So there's only one right now. So basically, we're considering a bill that is essentially an earmark, which are currently prohibited by House rules. Mr. Winberg, moving on, how do you determine whether granting the exports is in a public interest?
There's a number of factors that we evaluate. We look at economic impacts, international impacts, security and natural gas supply, and environmental impacts, among others. But those are the four chief factors that we evaluate with the public interest review.
So you examine the impact of LNG imports on domestic supply of natural gas and the international impacts of LNG exports. Is that right?
Yes, sir.
Do you think that the DOE process is valuable for ensuring that U.S. LNG exports are strengthening the energy sector of our allies and not benefiting those who seek to harm us?
Yes, sir, I do.
Good. I think we should be mindful of the effects of removing DOE from the LNG export approval process. Shouldn't we be careful before we greenlight exports, unlimited LNG exports without consideration of our national security interests?
I think that's up to the Congress to decide, but whatever Congress decides, we'll implement it.
Okay, thank you, Mr. Chairman. I'll yield back.
Mr. Burton.
Thank you. Mr. Chairman, thank our witnesses on this panel. I have a comment, since I didn't give an opening statement, then I've got a question or two. Some of the comments I heard in the opening statements and some of the questions from the minority on the question period remind me of the debate that we had 3 or 4 years ago on exporting oil, crude oil. We were prohibited, we as a country, from exporting crude oil, and because of hydraulic fracturing and horizontal drilling in our shale formations, there became a fairly substantial price disparity between the domestic price of crude oil and the international price. The Arab oil cartel, or the OPEC oil cartel, artificially elevated the world price. And when we introduced my bill to repeal that Mr. Kramer was a big part of, and Mr. Flores and a number of other people in this committee, Mr. Cuellar on the Democratic side, we heard these complaints about national security and things of this sort. Well, what happened? We repealed the crude oil ban. As I speak today, we're exporting about 2 million barrels of oil per day. The U.S. domestic producer is now in the driver's seat. Supply and demand set the price, and the price on average is about half what it was from 3 years ago. It's coming up a little bit. It's a little bit between $55 and $60 a barrel, but it's been as low as 23. But it's darn sure not over $100 a barrel like it used to be. American free markets are determining the price of oil in the world, and we're creating trillions of economic benefit every year in the U.S. and overseas. So it's been an unmitigated success. Now let's look at natural gas. We literally have more natural gas capability, production capability in the United States than we know what to do with. We really don't know what the resource base is, but we know it's extremely large. By any normal economic assumption, we have enough natural gas, if we never found any more, to handle the expected demand in the United States for the next 100 to 200 years. So Mr. Johnson and I think Mr. Latta and a few others have introduced these two bills, 4605 and 4606, and they have the intention of doing for the natural gas markets what the crude oil export repeal ban did for oil markets. I don't think there's any downside to that at all. So I just want to put this in context. This country has been so blessed with natural resources, and then doubly blessed with an economic system based on freedom and free markets, free market capitalism, that we are literally the envy of the world. We are the dominant energy producer in the world, and we're going to be. And Mr. Johnson's bill is simply an acknowledgement of that, and says let's use this economic resource that we have to benefit the rest of the world and create more economic benefit here in the United States. Now, I have one question to Mr. Weinberg. The bill 4605 is currently constructed only deals with LNG, liquefied natural gas. I'm sure that the Department of Energy and the Ferc too is aware that there are other natural gas liquids that can be produced and can be exported. And, you know, I've asked Mr. Johnson to consider making a modification that his legislation would apply not only to pure liquefied natural gas, but to other natural gas liquids also. Mr. Weinberg, do you believe that if you support the bill, that we should make that modification so that we create a level playing field for all types of liquefied natural gas products?
The Department of Energy has responsibility for a public interest review for liquids also, as well as LNG. I think it's not my place to suggest to Congress as to whether they ought to modify or expand the modification of 46.
Well, let me rephrase it. You wouldn't, do you believe the department would officially oppose creating a level playing field for natural gas products to be exported? And the answer is no, we do not oppose it.
Congressman Barton, what I know is that we have an abundance of oil and natural gas in this country. Your statement I absolutely agree with, and I share the statement about the resource base, as well the reserves and the resource base in the United States, and our opportunity to become a continued long-term net exporter of natural gas liquids and oils is something that's in the interest of the United States.
My time's expired. I appreciate the generosity of the chairman.
Mr. Peters.
Thank you, Mr. Chairman. Just thinking about Mr. Barton's characterization of the abundance of energy, which I think we all agree on, he knows better than anyone. It's just, this isn't your issue, but the rush to drill for oil off the coast seems incredibly ill-timed, given that abundance. I guess except in Florida, which the federal government seems to think is the only coastal state with tourism. But that's not your issue. I guess the issue I wanted to ask you about, Mr. Winberg, is the nature of the public interest discussion. I think clearly one concern when that law was passed was supply, and I think that that's been fairly well established. That's not so much a concern of ours if we have enough energy for the next 2 centuries. Mr. McNerney also talked about the national security interests that may come up in the movement of natural gas. But the third was, we mentioned, and I just want to explore a little bit, was the environmental interests. Can you describe for me what the nature of the analysis is around environmental concerns when you're talking about making this public interest determination?
Actually, the environmental assessment for LNG under the Natural Gas Act falls to FERC, so we're a supporting agency, so they do the vast majority of the NEPA review. So I apologize, I can't speak to detail.
All right, I may be confused then. Is Mr. Stanley, maybe you can answer this. Is this environmental analysis going to be eliminated as part of the proposed bill? Because it was...
No, the process by which the siting and construction operation is conducted is still going to have certain coordination between different agencies for approval. So, for example, for these marine gas terminals, we would have coordination with the Coast Guard, Department of Transportation.
I'm talking now about the movement of natural gas, because my understanding was that there was a analysis in the Mr. Winberg's section on the environmental impacts associated with the import and export of natural gas. Is that not right? Am I reading that wrong? Maybe I misheard.
That is correct, but it's a joint effort between FERC and DOE.
Okay, so if the bill passes, and I understand what it would do, it would be to eliminate this public interest analysis associated with the movement of natural gas, whether you did it or FERC did it. Isn't that right?
Well, our read of 4605 is that it does not appear to affect FERC's requirements under the Natural Gas Act.
FERC's requirements are associated with the siting of a facility, not with the movement of the natural gas. Is that correct?
That's correct.
Is there today an analysis of the environmental effects associated with the movement of natural gas, import or export, that would be eliminated by virtue of this bill?
Potentially, yes.
I think so. So what I want to know is what are the components of that analysis which we would be giving up? What are the things that you're looking at as an assessment of the environmental impacts of the import or export of natural gas?
I don't know the specific components of the environmental impacts portion. I certainly can get that over to your office.
Would love to see that. I think we ought to know kind of what we're giving up. In particular, you know, I'm a little concerned. I think natural gas offers a lot of potential. I think we all understand it burns cleaner than coal, but we had in my other subcommittee, we had Mr. Pruitt in, and he didn't seem to be as convinced about the need to control fugitive methane emissions as I think some of us are. And that fugitive methane emissions can really surrender the benefit of natural gas from a climate perspective, even though it burns cleaner than coal. If you're losing a lot of it to the atmosphere in terms of extraction or distribution, we're losing that benefit. And I think we'd like to know that. I think that might be part of the analysis that we want to look at and associated with import and export. So I would like to have that information and appreciate your sending it over.
Yeah, be happy to do so.
Thank you, Mr. Chairman. I yield back.
Mr. Shimkus.
Thank you, Mr. Chairman. Great hearing. Thanks for being here. Would our clerk put on the, and members on the committee have seen this photo before numerous times. Some may have not. Import terminal, and I point to the front. I'm not a Navy guy, so what's the front? The bow. The bow. The bow. And on the front of the blue terminal, which is really a ship, on the bow, you see in English the word independence. Can anyone guess where that is located? It would give you the idea that it might be a North American placed vessel or a vessel placed in England, an English-speaking country, but that's actually an import terminal in Lithuania. And I note that because it addresses this issue about the importance of national security of LNG imports and exports for those of us. So the public interest, I think, Mr. Winberg, as we talk about this vague term, and then you kind of define down, part of it is the public interest to our strength with our allies and friends, Lithuania and the Baltic countries. I spent a lot of time dealing with their interest, former captive nation, former Eastern European country that has been part of a concerted extortion by the Russians using the tool of energy. This has allowed them to free themselves from the shackles of Russian energy extortion. And so it talks about the great ability. Now, they've been crying for U.S. LNG, and I think they finally this has been up for about 18 months now, and I think they have now recently signed a contract with Chevron for, quote unquote, like you said, the molecules are molecules. The world market's the world market. That's why I keep trying to preach to them. But U.S. LNG, they want U.S. natural gas into their port. So that's going to happen. And it's a sign of, for them, freedom and democracy, strength, and alliance with the West. So that's why a lot of us are just so excited. And just look at the Eastern European, the former captive nations, just go from the Baltic Sea down to the Black Sea, and you see the turmoil, and you still see the stress that other countries have. Hence the discussion that we're having about smaller LNG terminals in this debate. There's been a good hearing in that for this terminal in that region of the world, there are smaller LNG terminals being debated and planned for up the Baltic Sea into Finland and those areas which will not have the need for a larger terminal or may have difficulty with ice, where a smaller terminal can provide the access. Now, a lot of us had a chance to, well, not a lot of us, but some of us had a chance to go down to see Puerto Rico and during a hurricane. And we're talking about really energy security for them. A smaller LNG terminal would be great for them. It would be part of the all-the-above energy strategy if you want to help Puerto Rico free themselves from kind of the capture they have because they're an island nation and have a failed electric system. And there is a lot of this debate. So I wouldn't be so quick to rush judgment on the importance of incentivizing smaller LNG facilities, because, or at least freeing it up and giving some more access for expedited permitting, because there is a I believe, a pent-up demand from that worldwide. And I think now with the current hurricanes that have gone through, the signal has been sent that even our own citizens of our country would probably be benefited by that. So, Mr. Winberg, in my 18 seconds left, just can you confirm that the public interest in national security is part of the public interest debate?
Yes, absolutely, I can confirm that. And our DOE proposed rule for small facilities is exactly targeted at, to a large degree, at Caribbean nations, island nations, and on islands that truly do need LNG in small quantities.
And I would just end by saying an LNG terminal is probably not $100 million. It's probably in the $2, the $3, or the $4 billion in construction and economic benefits. And I'll yield back.
Mr. Tonko.
Thank you, Mr. Chair, and thank you to our witnesses for joining us tonight. Mr. Stanley, am I correct that under PURPA, qualified facilities must have a capacity less than 80 megawatts?
Not entirely. There's a nuance that I should point out, which is that cogeneration facilities, which are also qualifying facilities, can have larger than 80 megawatt capacities.
Okay, and is that threshold stated in PURPA statute?
Yes, it's a statutory threshold of 80 megawatts.
Okay, thank you. The current existing presumption is that qualified facilities with a net capacity above 20 megawatts have non-discriminatory access to interconnection services and markets. What types of barriers exist for small producers that may hinder their ability to get their market access?
The presumption that threshold is based on is that the much smaller qualifying facilities are simply less sophisticated parties that don't have the resources and personnel or experience interacting with the market that larger energy companies that might be making the larger QFs would have. So it comes down to technical expertise, experience in having their power provided to markets in other contexts, things like that.
And transmission services or interconnection ability?
Sure. Everything from the process of getting connected to actually ensuring that they get dispatched.
Okay, thank you. And is this threshold for presumption of non-discriminatory access in the PURPA statute, or was it established by Ferc?
Ferc established the 20 megawatt limit.
Was that after the EPA Act of 2005?
Yes, that's correct. Yep, it was in the, yes.
So in 2006, Ferc conducted an extensive proceeding and established a presumption that all facilities larger than 20 megawatts have non-discriminatory access to market. What was the reasoning behind the 20 megawatt threshold that 12 years ago?
In part, the 20 megawatt number is used in other parts of FERC's regulations. For example, it's the dividing line between the large interconnection and small interconnection agreements that we have in other contexts. It is, for creating a rebuttable presumption, a line has to be drawn somewhere, and it accorded with other parts of FERC's regulatory regime.
And what is your understanding of the significance, Section 3, let me first state, Section 3 of H.R. 4476 would lower that threshold to 2.5 megawatts.
Yes.
So what is your understanding of the significance of that threshold?
Of the 2.5 megawatt
Yes.
threshold? That presumably this would be enacted because the judgment of the subcommittee in the House is that the times have changed such that even smaller qualified facilities have sufficient sophistication to get access to the markets on a non-discriminatory basis. I assume that would be the intent of the bill.
I have heard concerns from a number of industrial energy users. Apparently, some industrial qualified facilities are certified as small power producers. Can you explain how or why this happens?
Do you mean as opposed to being cogeneration facilities? Is that I'm not sure about the specific facts of the case. Do you have any more information about that?
Not offhand, but just wondering if you have any sense of understanding the significance for that threshold.
I would imagine that in the ordinary course of business, because cogenerators are not limited to 80 megawatts, they would typically choose to be designated as a co-generator. So nothing springs to mind immediately as to why they would make that decision.
Well, to clarify, not all industrial qualified facilities would be exempt from this legislation.
No.
Okay, thank you, Mr. Danley. Well, Mr. Winberg, you had earlier explained the factors of DOE using factors to determine whether an LNG export project is in the public interest. And obviously, our nation's energy use and needs change over time. So I, for one, believe that this is a feature of the system, that these projects are evaluated and that someone is assessing the consequences for American consumers and manufacturers, as well as our energy and national security. So, I think that's important to bear in mind as we go forward with some of the bills that are introduced and the changes that would be produced. And with that, I yield back, Mr. Chair.
Mr. Latta.
You're good. Well, thanks for being here, and thank you very much, Mr. Chairman. And if I could follow up a little bit where my friend from Illinois was with his discussion on the LNG exports going into the Baltic nations. Mr. Winberg, DOE's recently issued a proposed rule for small-scale LNG exports. Small-scale LNG projects could serve markets in Latin America and the Caribbean, but these job-creating projects are bogged down with a lot of unnecessary red tape. Where do you see the greatest potential for small-scale LNG projects are right now for U.S. producers?
As we talked about earlier, I think primarily the Caribbean, Central America, and South America, possibly some European countries as well, but for those small loads on seaborne trade, distance becomes an issue if you've got...
Right, and besides, when we're talking about Lithuania and Latvia and Estonia, when you're talking about other European countries, who would you have in mind on that? Because I know that some of us were over to see some of the LNG ports out around in the Iberian Peninsula. But where else would you see?
DOE doesn't take a position on where LNG ought to be traded. We have free trade agreement countries and non-free trade agreement countries. So as we get in the applications, we review them based on whether it's FTA or non-FTA, but we don't take a position on where LNG should be traded.
Okay, and under the HR 4606, how would this improve the process for permitting these small-scale facilities?
Our read of 4606 is that any small export or import would be granted without modification or delay. So it would be in effect the same as procedure that we would use with FTA countries.
Okay. Let me follow up in a little bit of discussion when we were talking about Puerto Rico. As we all know, that Puerto Rico's grid was devastated by Hurricane Maria, and here we are more than 100 days out, and power restoration is still not completed. What role could a small-scale LNG play in Puerto Rico's grid modernization?
Well, I think the role that LNG would play would not be so much in the grid modernization, but perhaps in the electricity production modernization, which arguably is a part of it. They burn a significant amount of oil, so there are opportunities for LNG to be brought into Puerto Rico to displace oil, lower emission, higher efficiency units. So there are some significant advantages.
Okay. Thank you very much, Mr. Chairman. I'll yield back.
Mr. Losack.
Thank you, Mr. Chair. Great discussion today, as always. I always learn a lot when I'm in this committee, and we have great witnesses and great questions from my fellow members. Once again, I have to brag about Iowa and wind power.
Time has expired.
Yeah. Too bad. Look, Iowa is a success story when it comes to wind energy. Texas is as well. Texas produces more wind energy than Iowa, but for the
Give
size
him
of
more
our-
time, Mr. Chairman.
But for the size of our state, we're doing great. And the fact of the matter is, over a third of our electricity in Iowa comes from wind. And it's just been a great story. It's good paying jobs, plays a critical role in our economy. In 2016, Iowa produced about 20 million megawatts of wind energy. And by 2020, I think we're going to get to 40% of our electricity is going to come from wind. So, obviously, when we move forward on PURPA, I think it's really, really important that we ensure that wind energy is deployed in the most cost-effective manner for my constituents, and also ensure that the federal government continues to play a role in promoting renewable energy. I think that's absolutely critical going forward, and I think we can get some good bipartisan agreement on that. I really just have a question for Mr. Stanley. There are concerns, of course, about this qualified facility developers, who've been developing some large wind farms, and they intentionally disaggregate and place portions of the project more than a mile apart to ensure that it doesn't exceed the PURPA megawatt threshold. How will this legislation, Mr. Stanley, going forward, ensure that qualified projects are not subdivided to take advantage of higher PURPA prices?
The intent of the legislation is to allow the presumption of that 1 mile rule, which is the bright line rule currently established by Ferc regulation. That at the moment is an absolute rule. It would convert that to a rebuttable presumption, and it can be rebutted by a series of statutory listed factors, whether they share common financing, if the land comes from the same purchase, if they share an interconnection, if they use the same resources, if the same people own it. That would be the list of the various factors, and if the presumption is rebutted, then having crossed that 80 megawatt threshold, they would not qualify for the other benefits that come with being a qualified facility, most importantly, the mandatory purchase obligation.
So that's how you see this implemented in that sense, then, what FERC will do to implement this?
Say that again, please?
So that's how you see the implementation going forward?
The FERC will implement it by, when asked, presumably conducting a review on the fact-based statutory factors.
Right.
Right now, qualifying facilities are certified by one of two ways, primarily through self-certification or by having a FERC review process. So it may have an impact on that second of the two ways of being certified, which is really a minority of QFs get certified that way. And then for the others, presumably people who have an interest that is adverse to that determination or that self-certification would bring a petition to FERC to review it.
Okay.
That's my presumption. I'm not sure, of course, based on what the bill currently reads.
Yeah, because it is a big issue. There's no question about that, and I'm sure not just in Iowa. In your opinion, also, does it make sense to allow states to require QFs to participate in a competitive solicitation process to ensure that renewable energy is deployed in the most cost-effective manner?
To the extent that the subcommittee in Congress does not want to advance PURPA's goals under the current mechanisms that PURPA has, then having a competitive process is another viable alternative.
Okay, thank you. Thank you. I yield back, Mr. Chair.
Mr. Johnson.
Thank you, Mr. Chair. I appreciate it, and thank you, gentlemen, for joining us today. Mr. Winberg, LNG exports and PURPA reforms are two issues very, very worthy of our committee's consideration, especially as it relates to bringing our energy policy into the 21st century. I'm encouraged by this administration's effort to find sensible ways to unleash America's energy. Secretary Perry and the DOE have carried out that approach through their continued approval of LNG export permits and through the agency's work on small-scale LNG exports. But DOE can only do so much, as the current law pertaining to LNG exports was written at a time when our energy landscape was very different than it is today. The bills we're discussing today reflect the realities of our energy abundance, with over 2 trillion cubic feet of recoverable natural gas beneath our feet. Congress and this committee in particular have done a lot of work to advance bipartisan bills that encourage LNG exports. Last Congress, LNG export bills advanced not only in the House, but through the Senate as well, always with bipartisan support. So I think I've heard you say it before this morning, Mr. Winberg, but because these are my bills that we're talking about today, I'll sleep better if I hear you say it again. Will you help continue that work by working with the committee and me on these bipartisan bills that we're discussing to advance LNG exports?
Yes, absolutely. We'd be delighted to help.
Okay, good. Do you know if the DOE has plans to further its work on expediting and reforming LNG export, the process, the permitting process?
We do through our latest notice of proposed rule, which we came out with on September 1st of last year, and that specifically addresses the small-scale exports. And so we've received comments on that. It's not finalized. It hasn't been published in the Federal Register, but we are reviewing the comments, and we plan to publish shortly. And that is fairly closely in line with 4606.
Okay, all right. My colleague, Mr. Shimkus, touched on this a little bit. You know, for too long, we've seen countries like Russia use energy as a weapon. They have a stranglehold on Europe's energy supply, but with our LNG exports, that's already started to change. How, in your opinion, have U.S. exports of natural gas helped our allies and strengthened our hand diplomatically on the global stage?
I think the access or the production of U.S. fossil energy resources, whether coal, oil, or natural gas, have had a profoundly positive impact with our allies and helping them to ensure energy security and therefore security in general, much as it has here in the United States.
Well, you know, Russia gets about, and experts differ on the exact number, but somewhere on the order of about 50% of their revenue comes from the sale of oil and gas. About 80% of that resource runs under pipelines that go across the Ukraine. 70%, I've heard, of their oil and gas sales are to our friends and allies in the region, and they've been known to turn the switch off when things weren't going their way in the past. I believe that this gives the administration, especially in light of the events going on in the world and the temperature of our relationship with the Russians in particular today, a new and different kind of leverage than we've had in the past. Would you agree with that?
Absolutely.
Okay. All right. Mr. Chairman, I yield back.
Mr. Schrader.
Thank you, Mr. Chairman. Good hearing. I agree. Mr. Stanley, you indicated that, or seemed to indicate that very few self-certifying applications come through the system, and I got a pretty extensive list of folks that do self-certify in my state. We've got over 2,000 megawatts here in just a little over a year and a half. Could you comment on that?
I think I may have been misunderstood. We get about 2,000, roughly 2,000 self-certification requests a year, and just a handful of the Ferc certifications in which the agency does the certification on behalf of the entity.
Okay, because there clearly is a ton of it going on, and we sent you all a letter, many members of the committee, including myself, back in June, talking about the gaming of the system. I've got a couple of great examples here where Fresh Air Energy in Jefferson County, Oregon, has 3 different applications that were approved for 79.66 megawatts. You know, just under that 80, and then again in Klamath County, again Fresh Air Energy has 5 5 successful sightings for 80 megawatts. So clearly, we need to be doing something with the system to prevent that gaming. From your technical review hearing, what's the current state of play from the commission with regard to solving some of these problems and dealing with that 1 mile limit?
So the commission was in receipt of the oral presentations at the technical conference and the post-conference submissions, and it is currently under review before the commission.
Okay, okay. In your testimony, you comment about the rebuttable presumption, and you elaborated here about the conditions that might be used to deal with some of these instances. We also talk about resources. Without having that clear, bright line, what sort of resources is the commission going to need to be able to adequately get through the application processes you now have?
It is difficult to predict the number of people that might challenge a self-certification. If challenges come up, then it's going to require a fact-intensive review in some mechanism. I can't imagine what the mechanism would be yet. We haven't dealt with it. But there would have to be some mechanism to review the facts that are under the statutory factors, and it would require a significant amount of personnel time if we find ourselves facing.
So you would need more resources than you currently have?
I'm not sure that's true. I just know that it's going to require us to devote time and manpower to a subject that we've never had to deal with before.
Okay, so either you have a lot of extra employees right now, or you can easily, or you need more people to deal with the process.
Presumably, but depending upon the shape of the final bills that are passed, we could find ourselves having less work to do on other subjects.
Okay, okay, very good, very good. Talk a little bit about the state-by-state determinations rather than having Ferc do it. How would that, to your point a moment ago, affect your workload?
Do you mean the state-by-state determinations as to whether there is need or a competitive solicitation process? That would, it would not directly have much of an impact on Ferc staff time. That would really have more to do with whether or not the QFs are even able to participate. So that really is an issue of whether or not the subcommittee wants to abandon this national policy. It's not a resources question for us. In the
And how would that affect the industries themselves that are the partners, our energy partners?
Well, depending upon what decision each state makes, the effect could be that there are less incentives for qualifying facilities of different types to put forth the effort and the risk of trying to develop a generation facility. It could be that has a stultifying effect, but in other areas where there are competitive markets, it may not. It is difficult to predict in the laboratory of democracy the different possible outcomes. This is one of the great problems with PURPA, is how complicated it is with all the different state regimes for avoided cost calculations and the like.
Shifting gears a little bit, we haven't talked a whole lot about the industrial qualified facilities. What degree of problems with the gaming issue are presented by these facilities compared to the others?
When you say the industrial ones, I
cogeneration.
Okay, cogeneration, right. There is cogenerators are in a really different category from the small power producers. They are very often in industrial facilities that are in fact themselves net consumers of electricity. They're either using the heat that's produced by for industrial processes to generate electricity after the process is over beforehand, and this is simply a way to make money and be more efficient in the use of the generation.
So not part of the problem?
When it comes to gaming,
yeah.
No.
Okay, now you go back, thank you.
Mr. McKinley.
Thank you, Mr. Chairman. And I applaud Bill Johnson's legislation on LNG. I think this is something we've needed for some time, and he's addressed a problem that is starting to emerge, or issue of how we might be able to help out with that. Our districts are right opposite each other. The only thing that separates his congressional district and mine is the Ohio River, and that's just a line on the map. So we're in the middle of the Marcellus and the Utica shale gases formations, and we're seeing this resurgence as this country is pivoting away from fossil fuels or coal in a way that we have an opportunity to take advantage of the Marcellus and Utica shale gases that are there. It has had a profound effect
on our valley, improving the morale and the hope that we're going to see in this country of some positive things happen with that. We're now at a point between our two districts that with the Marcellus Utica, we're producing 50% of all the shale gas in this country. 50%. That's incredible. The opportunities then that come with that. So I thank Congressman Johnson for that. From what I can gather, talking to EIA, is that this shale gas, the potential that we have in these two formations, could provide all the gas for this country for 58 years. 58 years. That's only with 50%. Remember, the rest of the country down in Texas and elsewhere, they've got shale gas formations there coming. But just from the Marcellus and the Utica, we could provide all of the gas in America for 58 years. So it really is opening up a new opportunity for us. And what we have to do is get this bill passed and continue to do with this. Some of the critics say that if we export our LNG, it's going to raise prices. That's not been proven to be true. Not accurate at all. There's just unimaginable opportunities that we have if we can pursue this. And what the impact is for my district in West Virginia. There's a study out done by the Fraser Institute that ranks around the world about 97 different jurisdictions, states, countries, about where would you put your investment in fossil fuels? Where would you invest in energy? 2 years ago, West Virginia ranked 22nd in the world where they should invest. Last year, we ranked fifth best place in the world to invest because of what this formation, what it's going, the opportunity we have in creating that. So we're seeing as a result of that, we're seeing now that we have the second fastest growing GDP in America, in West Virginia. We're seeing Shenhua over in China investing $84 billion in West Virginia, is trying to explore and use this gas to try to help create jobs for people with this. So I see just a series of things, but yet we hear pushback from some people. We don't want to do this. We want to leave that gas in the ground. So I'm saying what I don't understand. I'll start with you, Steve, or excuse me, Mr. Winberg. You and I have known each other for too many years. Why would people want to stop something that this momentum that is recreating wealth, opportunity, and an economy and strong families and keeping them? Why would people stop that?
Sir, I really can't answer that question on why people would want to stop it. But to your point, in the Marcellus and Utica area, there are numerous opportunities. There is an LNG opportunity. We need more pipeline capacity to remove that rich resource that you have in your state and in surrounding states and move it into LNG terminals, for example, at Cove Point, to take advantage of the liquids in the in the Marcellus shale for ethane production, which then goes into chemical production. The opportunity to move that gas up into the northeast where it was so badly needed just a couple of weeks ago. So numerous opportunities there. You can articulate them much better than I can.
Yeah, I think with the ethane storage, you and I have had meetings about that, where we're, instead of sending it elsewhere, is that we'll be able to use that here in our area. That's positive. But I also want to emphasize to you, again, Mr. Winberg, I'm not trying to go away from coal. I just think we can have a dual track in energy dominance. And this is an opportunity. We just have to continue to explore it and put more money into research and how we might be able to clean coal technology, as well as we're developing this petrochemical industry in other than the Gulf Coast. Not that I don't I don't support my friends in the Gulf Coast. I think as a safety valve, we should have someplace else as well. So with that, I yield back my time.
Mr. Green.
I do represent the Gulf Coast. I want to thank the chair and the ranking member for this hearing today. Both PURPA and LNG exports are issues that in our area I care deeply about. And to follow my friend from West Virginia, when folks at my meetings come up and say, we want to leave it in the ground, I said, that's not a Texas value. If we can sell it to someone or build a plant. And I have to admit, on the export of LNG, I was concerned because the upper Texas coast, well, literally most of the Texas coast from Corpus Christi over in Louisiana, is a huge petrochemical complexes. And with the reasonable price LNG, we've seen huge numbers of expansion in new chemical plants just because of the availability of the natural gas and the different molecules that you get from there. I was concerned that we may price ourselves out of the market, but I haven't seen that. We haven't. We have, you know, Cheniere there in Louisiana, and we have a number of ports along the Texas that have permits in the process, and they're not small ones. They're very large. And in fact, I had a joke a few years ago that if you had a 5-foot ditch that ran from the Gulf of Mexico into Texas land, they wanted an export permit for LNG. And if you do the small ones, you may end up making that truthful. But one of my concerns is I've always been a very big supporter of NEPA, but smaller plants may not have that issue. But I'm concerned about the exemption of that for these smaller plants, because it wouldn't be unusual for maybe a company to build 5 export facilities that was just below the level, and so they could get past the NEPA review. So I think our committee needs to look at that. Under the, Mr. Winberg, the small volumes, like I said, is important. Under the DOE proposed rulemaking, how many companies would qualify for the streamlined process for quick expedition? Do you have any idea? How many companies that would qualify for that streamlined process?
Yes, sir. If you're asking about the current applications that we have.
Either the current applications or ones that have been built, but.
At present, there's only one that would qualify, and that's the Eagle Maxville LNG small-scale facility. I do not know how many other developers or potential LNG exporters might be considering small facilities. We have heard there are a couple people out there that are interested in this, but we haven't gotten any applications in, so I can't comment on a specific.
Okay. Do you have an estimate on what the daily volumes increase would be under such a rule if it became final?
I don't have an estimate, but the limit that we would have for the small-scale facilities would be 0.14 billion cubic feet per day for a facility. But again, not having an estimate on how many might try and avail themselves of this small-scale opportunity, I can't give you a total number.
DOE in its proposed rulemaking required a small volume exporter to meet categorical exclusions critical under NEPA to be approved. Can you tell me why the DOE felt it was important to include NEPA protections under this rule?
Yes, I can. It's because the small-scale facilities, based on what we have seen, would be, the primary markets would be the Caribbean, Central America, and South America. And without a small rule exclusion or a small facility exclusion, the cost to build a large facility for that many potential end-use points, we believe, would be prohibitively expensive.
Okay. One of the concerns I have is both when Ferc does it, does Ferc also require a NEPA review?
For the siting construction, yes.
Okay. So is there any duplication between what DOE does and what Ferc does for the NEPA review? Is there any?
In fact, in our review, you are a cooperating agency, correct?
Correct.
So yeah, there would be no overlap.
Okay, so there's no dual regulations or oversight.
The statutory regime neatly divides the responsibility into 2 different buckets: Ferc for siting, construction operation, and DOE for export.
Okay. I'm out of time, but one of my concerns is that the bill today would take away what the DOE has done on the rule, and I have a concern on that. Mr. Chairman, obviously I have a lot of questions, and I'll submit them.
Great, thank you. Mr. Flores.
Thank you, Mr. Chairman. I appreciate the panel for joining us today on these important pieces of legislation. Mr. Danley, I have two quick questions for you. The backdrop for the first question is this. Under the current framework for the Natural Gas Act, FERC has delegated authority over LNG export facilities. And in your testimony, you have stated that H.R. 4605 primarily concerns the authorities of the DOE. The DOE witness seems to agree with that. Because he stated the bill makes no modification to FERC's jurisdiction. And so we need to make sure we get this on the record clearly. And so the question is this, does H.R. 4605 affect or expand FERC's jurisdiction in any way?
Upon my reading of it, no. But if you have a specific idea, I'm happy to talk more about it.
No, I mean, I read it the same way you
Okay.
do. And so we just need to get that into the record so that some of the other comments that have been made here today are rebutted by the testimony of our expert witnesses. The next question is, as you're probably aware, there are new technologies to transport natural gas and natural gas liquids other than in an LNG form. And so because of that, they can be transported either in vehicles or in vessels that are not LNG vessels, and also in ways other than pipelines. And so I understand that DOE has determined that imports and exports of these mixtures should be regulated under the Natural Gas Act. Since the export facilities for these different types of products are not LNG terminals and they're not connected to interstate gas pipelines, FERC doesn't appear to have any apparent authority over siting and construction. So if H.R. 4606 were to become law, would FERC take that same position that they do not have jurisdiction over the export of these products, since it's not LNG and not connected to pipeline?
I cannot predict what the commission will determine as far as what its jurisdiction is, but the way I read it here, it would remain the same. There's no jurisdiction.
Okay, I think you've read it correctly. Thank you. I'll yield back the balance of my time.
Gentleman yields back. Would note that votes have started on the House floor. We're going to do Mr. Kennedy, and then we're going to take a recess until we come back after vote. So Mr. Kennedy's recognized.
I promise I will be brief. With the eyes of everybody in this room now upon me to be so. I want to thank the witnesses for coming. I want to thank the chairman and ranking member for an important hearing. Very helpful on a number of issues. Mr. Stanley, it's a pleasure to meet you. We have not had a chance to meet personally yet, but I appreciate your presence here. As you might be aware, our office has worked very closely with a number of folks at FERC, including your predecessor, on a couple pieces of legislation. I know you're not here to talk about one of them today, but I did want to try to clarify a couple of things. You testified over in the Senate back in October about one of those bills, the Fair Rates Act, that has passed unanimously out of by this body already, this Congress, and passed unanimously out of the House of Representatives again last Congress as well. We worked very closely with FERC in the drafting of that legislation. Your predecessor had testified as well, largely in support of that. I gather from your testimony on the Senate side that you have some reservations there. Candidly, looking at some of the testimony, I'm not entirely certain I understand what those reservations are. I don't want to put you on the spot, given that you're not here today to speak about
I'm happy to answer questions about it.
So the point of the legislation is to try to make sure that consumers always have at least some knowledge as to and a voice in some of the decisions that are being done by FERC. What happened, the legislation itself was in response to essentially a forward capacity auction, FCA 8, several years ago, where forward capacity prices, because of a shortfall, went from $1 billion before to $3 billion to then $4 billion to $3 billion, so $10 billion over the course of 3 years. And in that specific auction, deadlocked 2-2. Now, what was interesting also about that deadlock is a Democrat and Republican appointee was on one side and a Democrat and Republican appointee was on the other. Because there was no a 2-2 tie, because of a gap, in my view, of the way that the statute was drawn, a 2-2 tie becomes, in effect, an approval by operation of law, and there's no way for consumers to then appeal it. What this legislation seeks to do is to say a 2-2 tie should enter as a decision so that that can be appealed. The mission of FERC, I believe I have it right, or part of the mission, is to, quote, assist consumers in obtaining reliable, efficient, sustainable energy services at a reasonable cost through the appropriate regulatory and market means. Obviously, putting them in a circumstance where you have this tripling and then quadrupling of these capacity rates without any measure then to get a rehearing or justification for that, particularly given the unique circumstances that surrounded forward capacity auction number 8, seemed ripe for a fix to that statute. Clearly, the House of Representatives agreed. It was a bipartisan bill. Again, it passed actually on the first day of the Trump administration. So I understand your reservations. I'm also cognizant of the fact that I promised the chairman here I'd be quick. All I'm asking for is some engagement with you and your office to try to understand in a bit more detail what your concerns here are, as I believe that the bill was meant to address that concern.
I would be delighted to work with you. Do you want me to express the reservations I did before?
To keep my friendship with Mr. Upton, no.
Okay.
I'm watching that 2 minutes. It's been 4 now.
We'll follow up.
All right, go
Thank
ahead.
you, sir.
All right. All right. Thank you very much. We are going to have to come back. I know Mr. Wahlberg's got questions that he wants to ask, and perhaps some others. I think it'll be pretty quick. We're told that we have 3 votes on the House floor, so we'll do that, and then we'll come back.
Hearing will come back to order. And we'll proceed as before with the witnesses asking questions from, the members asking questions from the witnesses. Next question will come from the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman. Appreciate the opportunity to get well on my way to 10,000 steps. Mr. Stanley, thank you for being here, and we appreciate the work of your staff in assisting us, giving us information as we've developed our legislation to this point, so I appreciate that. State utility commissions set avoided cost rates. They have the authority to do a number of things, appropriate length of PURPA contracts. It seems to me that they have significant authority in implementing PURPA. I noticed in your testimony you stated granting PURPA exemption findings to the states would create state-by-state energy program. Essentially, I view this as providing state regulators with the tools to help each of them meet their state's electricity needs at the lowest cost to the ratepayers. Couldn't one argue that extending Ferc's waiver authority is keeping in line with state implementation coupled by strong federal oversight?
So, yes, you make a point here, which is that there is already some degree of balkanization in the way that PURPA is implemented, because the actual recovery under the mandatory purchase obligation is set at the rate that is established by the state utility commissions. There's no doubt about that. And this would be a further step in the direction of allowing the states to act independently of one another based upon their own either political or policy goals. The only difference is that there is, if a QF is capable of being guaranteed a recovery of some amount that is based upon an avoided cost rate, that is a thing that is different in kind, I think, not degree, from whether the rate is X or, X plus 5%.
It would still allow strong federal oversight if we move that direction still further.
Yes, there would be federal oversight of the utilities, as there already is, but there would be a different way that QFs would be functioning in the market in states based upon what the state legislature, or rather the regulatory commission wants.
Since PURPA was signed into law back in 1978, transmission access has become open to competitive generators. Organized markets have been developed, and even bilateral markets. There's robust trading in those markets with independent generators. Given that electricity sector has changed drastically, do you believe that implementation of PURPA has fully kept pace?
I agree with your point that there have been big changes, and in fact, Congress recognized this in 2005 with the passage of EPAC 2005, where it allowed the states to get out from under, or rather the utilities to get out from under the mandatory purchase obligation in the areas with organized markets. I do not wish to opine on whether or not PURPA has kept pace. There are definitely changes going on in the market, and it is properly the role of Congress to decide how to respond to those changes.
Okay, well, let me then add to that, or put it this way. Do you believe the current law represents the maturity of competitive markets, state renewable energy portfolio standards, investment tax credits, production tax credits, zero emission credits, reduced cost in renewables, and greater access to markets for smaller power producers?
Okay.
Try to put it all in there.
Yes. The answer is that there are a huge number of different policy vehicles available to state and the state governments and the federal government to achieve policy goals. And PURPA is but one of those tools that is used to achieve a goal. Some people say that it's abusively used and creates market distortions, and others say that it's a necessary requirement in order to promote this congressional mandate to encourage QFs being developed. That, as I say, is a question for your consideration.
I appreciate that. I won't ask the follow-up questions then on that basis. I'm a believer in an all-of-the-above energy approach. I believe a diversified electricity portfolio is crucial. With that being said, I fear PURPA is inhibiting my constituents from benefiting from the lowest cost source of renewable electricity. What Ferc policies would need to be modified to ensure the best deal for customers in moving forward. Could I get a smile?
I hate to say this, but I can't speak on behalf of the commission or predict its actions. Right now, the commission is reviewing the comments that came out of the tech conference, and we are actively working, as you're well aware, with members of the subcommittee here to talk about possible legislative reform.
Well, thank you. I appreciate it. My time has expired.
Gentleman yields back. The chair now calls upon himself for 5 minutes. And first of all, thank you and welcome all the witnesses. As many of my colleagues mentioned, U.S. shale has made America #1 in the world for natural gas. And that fact has allowed America to make our world safer, more secure, with cleaner air and cleaner water. Mother Russia has used their natural gas dominance to force Eastern European nations to cower instead of seeking freedom. Our LNG exports have changed that forever. As Chairman Shimkus said about Lithuania, I want to point out what's happening in Poland. Poland was part of the Iron Curtain. The first shots of World War II happened in Poland. Russia came in to counteract Germany. They were in that curtain till 1989 and beyond. They're a member of NATO. They broke away from Russian dominance, led by a worker from a shipyard, Lech Wałęsa. But they had an Achilles heel. Mr. Putin still controlled their energy, their natural gas. This past summer, guess what happened? A large LNG tanker, American tanker, from Cheniere, it's a Sabine Pass, docked in Poland. It docked in Gdansk, Mr. Wałęsa's hometown. That simple act said, goodbye, Mr. Putin, hello, Uncle Sam. And that same story is happening. Other nations we care about, like Japan, South Korea, and India. And I'll be honest with you too, this energy boom has been great for my home state of Texas. My first question is for you, Secretary Winberg. Can you talk about the administration's views on energy exports as a national security matter? Is there coordination between DOE, Department of State, Defense, USTR, Commerce, Ag, all the people involved in the trade are working together to make sure this happens, because natural gas is not just fuel and power, also big for agriculture. Their crops, their stock, their fertilizers come from natural gas. And so are you guys looking with all the other guys to make sure we seize this opportunity? Any questions, any comments about that?
Yes, we are, and I agree with your assessment of the value that U.S. energy has brought to our friends and allies around the world. We are working with other agencies, other departments, to continue that growth in U.S. energy dominance and our ability to export to, again, our friends and allies.
So again, just to confirm, you see this as an important part of national security going forward. U.S. exports of oil and natural gas.
And coal.
And coal, you betcha, yes. You betcha. Next one is to you, Mr. Stanley. As you know, Texans like to brag, we are big oil and gas, #1 in America for over half a century. That's not changed, but what's changed the last 10 years? Wind power. Texas is #1 in America by far and away for wind power. And we're concerned about the 1 mile rule with wind power. As you said, FERC determines if wind production is at the same site based on the 1 mile rule. Can you talk about how FERC decided that standard and whether it has been reconsidered over the years? Because people are concerned about that back home, 1 mile standard towards wind production.
Certainly. So the 1 mile standard was implemented after by Federal Energy Regulatory Commission regulation, and it is based upon a simple measurement of the distance from one of the facilities to another. There's nothing complicated about the specific site points of the location. It can become complicated when there are multiple generating facilities in propinquity with each other, but it is basically a fairly straightforward locational distance requirement. Wind and solar, which have larger footprints, are open to more difficult analysis, because you can say at what point, at what part of the, let's say the PV array, do you measure the 1 mile from, or how far apart do the individual turbines have to be? And so that is a consideration in an interest in reforming the 1 mile rule.
Okay, I'm out of time. One final question. It's very important for people back home. Are you both happy the Houston Astros are now the World Series champions? Yes or no, Mr. Winberg?
Coming from Pittsburgh, that's a very difficult question to answer.
I'm happy that you're happy.
Well played. Running for office. Again, we're done with the questions from members. I want to thank all the panelists. I apologize for the votes. This panel is adjourned. We'll recess for what? Second panel for a couple minutes. Just get the second panel set up, but thank you, thank you, thank you.
Thank you.
I'll take this gavel down for just a couple of seconds. I'm bringing Pittsburgh with me, man. I do apologize. Got to, man. And I apologize. Today, as you know, in DC is kind of a unique day, having some things happening on both sides of the Hill that are very important. And I just want to read you something from our whip. Members are reminded to remain flexible, as additional votes may be possible. So I just want to apologize before. We'll try to get this done as quickly as possible. And I'm so thankful you guys are here. And I'll start out with the first questions and stick to the 5-minute rule. Oh, yeah, opening statements. I've been going for it. Man, I apologize. No questions about the Houston Astros. We'll just go from my left to my right. Mr. Kavula? You recognize Kavula?
Kavula.
Kavula.
Mr. Vice Chairman, and Vice Chairman Olson, Ranking Member Rush, it's great to be back before you today, and in front of all the members who are here of the Subcommittee on Energy. Thank you for the opportunity. My remarks today address only H.R. 4476, the PURPA Modernization Act of 2017. I'm the Vice Chairman of the Montana Public Service Commission. Today, I'm also here on behalf of the National Association of Regulatory Utility Commissioners, or NARUC. NARUC is a nonprofit organization founded in 1889, and our members are the public utility commissions in all 50 states, the District of Columbia, and U.S. territories. It's our members who are primarily responsible, as Congressman Walberg has already pointed out, for implementing PURPA. I'd like to thank him for his efforts in working on this legislation, as well as his staff, and on behalf of NARUC, I'd like to express our support for it unreservedly. PURPA is nearly 4 decades old at today's point, and it reflects the reality of another era when renewables were scarce, demand was booming, and the country looked for ways to diversify its energy portfolio and shield itself from over-reliance on foreign sources of supply. Today, the world has changed dramatically. The U.S. Energy Information Administration reports that nearly half of utility-scale capacity installed in 2017 came from renewable resources. More than half of states, including my own, have their own renewable energy mandates, and even those which do not, such as Iowa, have shown substantial additions in renewable capacity, not because of PURPA, but because of the falling cost curve of renewable technologies such as solar and wind. A revision of PURPA, in other words, does not have to be anti-renewables, and this bill we do not consider to be anti-renewables. To the degree that PURPA was enacted at a time when renewable technologies were not the norm, that norm has changed profoundly. And there's been another significant transition too. Nearly all states today require power generation to be procured through competitive means. Even in states that do not have consumer choice or are restructured, monopoly utilities are nonetheless typically required to procure resources through competitive solicitations. In short, other events have transpired that have accomplished PURPA's twin goals of advancing QF technologies and introducing competition into the sector, rendering PURPA itself largely needless. PURPA mandates that power sales be at the utility's avoided cost, which on its face sounds unobjectionable. Conceptually, it means that consumers would pay no more or no less for PURPA resources than they would pay for non-PURPA alternatives. However, Ferc has long held that PURPA requires that states forecast a utility's avoided cost into the future for the purpose of offering QFs a long-term contract at administratively determined rates. This type of administrative pricing essentially requires states to guess at future market prices, allowing QFs to lock in rates that often substantially overstate the actual avoided cost. This approach is fundamentally different when compared to procurements that use competitive mechanisms like auctions or requests for proposals to discover the least cost resources. And indeed, courts have recently determined that competitive programs that attempt to implement PURPA are at odds legally with the law. Even California, which has done probably more than any other state to implement pro-renewable policies, has found that its PURPA program compliance is not in compliance, with the law, according to a recent court ruling. It's almost universally acknowledged that a competitive process is optimal, more optimal than administrative pricing, because generators there with a profit motive can vie against one another for the business of the nation's consumers, and that this is a best practice compared with prices set by a state commission through a trial-like proceeding where the cost-reducing aspect of competition is absent. Subsection 4B forthrightly acknowledges this and would allow competitive solicitations to substitute for administrative pricing regimes. In addition to the flaws underlying the so-called avoided cost pricing, PURPA's mandatory purchase obligation is a poor match to the relatively flat and sometimes even declining customer demand for electricity seen in many parts of the United States. In many parts of the country, new power plants of simply any kind may not be needed, a testament in large part to the increasing energy efficiency seen in the market, and yet unneeded power plants are in some places nevertheless being brought online due to PURPA's mandatory purchase obligation. In sum, PURPA's flawed approach to administrative pricing and its mandatory purchase obligation is harming consumers. Ironically, it's even at odds with the values of competition and conservation that are at the heart of PURPA itself. Again, I'd like to express NARUC's thanks to Congressman Wahlberg and the subcommittee members for considering this piece of legislation. Thank you.
Thank you, Mr. Kavula. The chair now calls upon Mr. Sparks, who is the Vice President of Electric Grid Integration with CMS Energy. 5 minutes, sir.
Vice Chairman Olson, Ranking Member Rush, Representative Wahlberg, and distinguished members of the subcommittee, thank you for the opportunity to testify regarding H.R. 4476, the PURPA Modernization Act of 2017. My name is Tim Sparks, and I am Vice President of Electric Grid Integration for Consumers Energy, referred to throughout this testimony as CE. CE is the principal subsidiary of CMS Energy and is Michigan's largest energy provider, serving natural gas and electricity to 6.7 million of the state's 10 million residents. CE and parent company CMS Energy was recently honored as the top performer for Michigan companies by Newsweek in its annual Green Rankings. Recent activities include helping our customers save over $1 billion through energy efficiency, producing 10% of our customers' energy from renewables, reducing our waste use for electric generation by 17%, removing 1 million cubic yards of landfill space in 2017, closing 7 of the company's 12 coal-fired power plants, opening 2 community solar power plants with a third on deck for 2018. We have learned that we can increase renewable generation and keep costs low for our customers. Enacted 40 years ago, PURPA mandates that electric utilities purchase power from qualifying generating facilities at forecasted prices set by state public service commissions. Now, 4 decades later, America's energy landscape looks nothing like it did in the 1970s, and it is therefore imperative that PURPA be modernized. H.R. 4476 takes a modest but important step in this direction. First, the bill provides clarification to stop abuse of the 1 mile rule. H.R. 4476 allows a challenge to be pursued should QFs not properly adhere to the criteria for calculating capacity and avoid gaming the system. Second, the bill recognizes that QFs between 2.5 megawatts and 20 megawatts already have non-discriminatory access to markets in those parts of the country with organized regional transmission organizations, or RTOs. RTOs assure unbiased open access to the electric transmission system within their footprints. Many of the QFs within which Consumers Energy was obligated to contract over 30 years ago now have access to the transmission system as an independent power producer. Without recognizing this access to the electric transmission system and electric market, Consumers Energy estimates its customers will pay approximately $18 million annually above market prices to QFs larger than 2.5 megawatts. This increased cost of our customers is formulated by the state-calculated avoided cost rate and applied to the QF's output. Recently, the Michigan Public Service Commission announced a new avoided cost rate for Consumers Energy. While we appreciate their steadfastness in doing their due diligence as mandated by federal law, the rate still remains well above market. To illustrate this point, in 2017, Consumers Energy received 683 applications from new independent generators looking to interconnect to our electric system as potential PURPA QFs. The 5-year average prior to the new MPSC rate order was just shy of 200 applications per year. The existing and potentially new PURPA contracts greater than 2.5 megawatts could cost our customers an estimated $35 million annually above market over the next 5 years. The third provision in the legislation recognizes the critical role state public service commissions play in keeping energy costs low for customers. The bill would allow greater flexibility to suspend the mandatory purchase obligation when additional electric capacity is not needed by the utility's customers. I want to be clear on one thing. Consumers Energy is not advocating for less renewables in our energy mix. In fact, since 2005, we have increased our renewable portfolio from 3% to 10% and will meet Michigan's new renewable requirement of 15% by the end of 2020. We have accomplished this through competitively bid renewable contracts and company-developed assets, unaided by any expansion of higher-cost PURPA QFs. In closing, PURPA served its original intended purpose of expanding renewables. However, as shown, the law is simply outdated and our customers are bearing the price. Between 2006 and 2015, Consumers Energy customers paid $300 million above market prices for electricity from PURPA generators less than 20 megawatts. It's time for this law to be updated, which is why we strongly urge the passage of H.R. 4476. I thank you for your time today.
Thank you, Mr. Sparks. The chair now calls upon Mr. Carl Rabago. Carl is the Executive Director of PACE Energy and Climate Center. Sir, you have 5 minutes. Opening statement.
Thank you, Chair Olson, Ranking Member Rush, members of the committee. From my perspective, against market abuse and improper discrimination. My name is Carl Rabago. I'm appearing actually in my capacity as a principal of Rabago Energy LLC. I worked in the electricity sector for about 30 years after spending 12 years as a cavalry and JAG officer in the United States Army. I've been a public utility commissioner in the state of Texas, a deputy assistant secretary at US DOE, a utility executive, and a frequent expert witness in state proceedings. I am also the executive director of the PACE Energy and Climate Center at Pace University in New York. I am not appearing before you in that capacity, but I do bring greetings from one of my office mates, former Congressman Richard Ottinger, who founded the center where I work and who co-drafted and sponsored PURPA when he sat in this body 40 years ago. The first thing I'm going to do is describe some very serious concerns with H.R. 4476. Second, I'm going to share with you some general thoughts about PURPA. H.R. 4476 should be rejected by this body in favor of a more measured and competition-friendly approach. Section 2 would eliminate FERC's 1-mile rule and instead mandates a rebuttable presumption, inviting utilities to use FERC litigation as an anti-competitive tool. The result would make project financing more expensive or even impossible for private sector small power producers who, unlike monopoly utilities, cannot pass their litigation costs on to captive ratepayers. Section 3 would create a presumption that all facilities 2.5 megawatts or greater in size have non-discriminatory market access, but the record does not support that presumption. Section 3 would expose many small power producers to market access discrimination and would stifle competition. Section 4 puts the utility fox in charge of the power sector henhouse. Under the bill, the monopoly utility can almost unilaterally determine competitors' market opportunities. It would take the small power sector back 40 years to the days when utilities ran their markets like cartels and consumers paid the price. In sum, PURPA modernization, as proposed in the bill, tilts the law so steeply in favor of monopoly utilities that it would frustrate Congress's long history of efforts to grow and improve competitive markets in the electricity sector. Now, just a few general issues. PURPA is 40 years old, but we still do not have truly competitive and non-discriminatory markets for qualifying small power producers and cogenerators. There are still many states with utilities, where utilities, and even some of their regulators perpetuate the very problems that led to PURPA. The real problem today is the need for modernization of a utility business model that is now more than 100 years old. Second, PURPA is working well in many places. The Michigan Public Service Commission recently concluded a case involving Consumers Energy and all the utilities in Michigan, demonstrating that it was ready, willing, and able to address questions about how to use IRP processes to inform avoided cost calculations, how to account for and keep up with market changes, and how to chart a course for future improvements in avoided cost methodologies. Third, there is a competitively significant difference between how utilities want to treat qualifying facilities and how they treat themselves. Utility shareholders would never build power plants based on a 2-year contract. They'd never limit their earnings to marginal cost-driven market prices. They can't even keep their existing generators running with those prices today. And utilities would never wait until there was an energy or capacity shortage crisis to begin planning for or building a new power plant. Fourth, market prices and competitive solicitations can inform but cannot replace the avoided cost determinations under PURPA. Market prices are the result of bidding strategies and a system designed to generate lowest short-run prices for energy and capacity, not build power plants. Competitive bids tell you the lowest bid anyone is willing to offer, but that does not tell you what anything is worth. To establish full and fair avoided costs, more work does need to be done by state regulators. That work increasingly includes evaluating distribution-level costs that are avoided by small generators, values that FERC rules and procedures may actually not fully assess. So finally, well, I'll just stop there and say thank you very much for the opportunity to address this committee, to address these important issues, and I look forward to standing for your questions.
Thank you, Mr. Bago, and thank you also for your service to our Army. Please pass on to Chairman Shimkus. I just want to say congratulations, congratulations. It's 16 years, your Army's beat my Navy twice, but 2 in a row, so well done.
As a former professor at West Point, I got to tell you, it felt good this year.
I can only imagine.
That doesn't cover all of the problems.
Well said. Our next witness is Paul Sisio, and Paul is he's the president of the Industrial Energy Consumers of America. Welcome back. You have 5 minutes, Mr. Sisio.
Thank you, Vice Chairman Olson and Ranking Member Rush and subcommittee members. Thank you for this privilege. Regarding H.R. 4476, the PURPA bill, we extend a thank you to Representative Wahlberg for exempting manufacturing cogeneration from the proposed changes to PURPA. The exemption recognizes that manufacturing companies are not in the business of generating and selling power and are not creating market problems. However, it is very important that the bill also exempt manufacturing company PURPA facilities that are classified at FERC as small power producers. To not do so would negatively impact their ability to produce low-cost power, thereby reducing competitiveness and jobs. Congress should not pull the rug out from underneath these capital investments that were made with PURPA regulatory assurances. Also, manufacturing companies who have installed wind and solar units inside their fence line or intend to do so in the future for purposes of reducing electricity costs or reducing greenhouse gas emissions would be negatively impacted. We do not believe that that was the intent of Mr. Wahlberg. We look forward to working with him to exempt this class of QF facilities. Regarding LNG exports and H.R. 4605, IECA is strongly opposed to this legislation. The bill presents members of Congress with a decision, either to vote for the bill and support the oil and gas industry, or oppose the bill and support your voters back home who risk higher natural gas and electricity costs long term. DOE's own LNG study that's entitled Macroeconomic Impacts of Increased LNG Exports from the United States illustrates that the net economic benefits of LNG exports almost exclusively serve the oil and gas industry and the public is impacted economically. The report concludes, quote, expansion of LNG exports has two major effects on income. It raises energy costs and in the process depresses both real wages and the return on capital for all other industries. That's all other industries, unquote. Raising energy costs, depressing real wages, and the reduction of return on capital on U.S. industries, one would conclude that increasing LNG exports cannot possibly be in the public interest. These impacts is exactly what happened in Australia. The bill is anti-consumer and removes the Natural Gas Act public interest test, which Congress put in place, which you put in place wisely. Importantly, the legislation is actually not needed. Volumes already approved by the Department of Energy for non-free trade and free trade agreement countries is equal to 71% of 2016 demand. That's 53 billion cubic feet a day. The excessive volume approved by the Department of Energy is a legal issue. Exporting 71% of U.S. demand cannot possibly be in the public interest. It is a violation of the Natural Gas Act. The DOE has failed to implement its regulatory responsibilities under the Natural Gas Act. It has not acted to protect the U.S. economy and the consumers from excessive future LNG exports. Congress is responsible for assuring the Natural Gas Act and safeguarding the American public with affordable and reliable natural gas. The Natural Gas Act is the law of the land. We urge the subcommittee to act to provide oversight of DOE-approved volumes and make remedy to protect the public interest. This is particularly important given that the 2017 AEO 2017 demand forecast indicates that 56% of the lower 48 natural gas resources would be consumed by 2050. I look forward to your questions.
Thank you. Mr. Riedel.
Good afternoon, Subcommittee Chairman Olson, Subcommittee Ranking Member Rush, and members of the committee. Thank you for the opportunity to testify today. My name is Charlie Riedel. I'm the Executive Director for the Center for Liquefied Natural Gas. CLNG represents the full LNG value chain, providing it with unique insights on the benefits LNG brings to the U.S. global economies. CLNG operates within the Natural Gas Supply Association, a national trade association that has represented the U.S. natural gas industry for more than 50 years. This gives us a deep understanding of the entire U.S. natural gas supply portfolio. I'm pleased to be here today in support of Congressman Johnson's efforts to improve the liquefied natural gas permitting process and encourage members of the committee to support his legislation. Representative Johnson has been steadfast in spearheading legislative solutions to improve the permitting process for liquefied natural gas facilities. and the time for action is now. As Representative Johnson has said himself, the window of opportunity for LNG exports will not remain open indefinitely. The U.S. is awash with affordable natural gas, and as other countries look to enjoy these same benefits the United States enjoys, we're in a unique position to meet the growing demand globally. However, there is a tight window to capture the market share, and providing regulatory and legislative certainty will help U.S. exporters claim our share of the global market. By allowing the United States to export natural gas after completing the FERC review process, as proposed in H.R. 4605, the Unlocking Our Domestic LNG Potential Act, a more certain and consistent regulatory environment would be created to unlock that future potential. The length of time for DOE permitting has varied widely to date. The first 6 LNG projects had to wait an average of 2.6 years to complete the permitting process. That period of review is unnecessarily long, and we can and should do better. The LNG export opportunity, the very reason we are able to have this conversation today, is because of our vast supply of natural gas. It is the supply that's growing by the year that underpins the economic and environmental benefits we can achieve with exports. Technological breakthroughs in the oil and natural gas industry have unleashed an energy renaissance, establishing the United States as the world's largest natural gas producer. As I speak today, the U.S. natural gas resource has reached an all-time high. According to the U.S. Potential Gas Committee, these numbers continue to increase, up 68% since 2005, according to the U.S. EIA. This alone is impressive, but consider this. During that same time, our total natural gas resource estimates also continued to increase. New domestic supplies of affordable natural gas have created competitive advantage for U.S. manufacturers, leading to greater investment in industry, investment in jobs, and creation of additional workforce. Experts forecast additional industrial investment of $135 billion to build 59 new manufacturing projects and expand 11 additional projects in the next 5 years. There are those that suggest we must choose between exports and our domestic manufacturing sector, but study after study tells us otherwise. According to a study from the Department of Energy, exports will not compete with our manufacturing sector for supply. And it's important to note that additional exports will be met by new production of natural gas. What we're finding is that LNG exports can and will react to both the global marketplace and domestic demand. Less than 2 weeks ago, the Northeast was hit by the bomb cyclone, one of the coldest weather systems to reach our shores in years, and natural gas met record-setting levels of demand admirably. As the bomb cyclone moved along the East Coast, the import customers of Cove Point facility in Maryland responded to price signals and delivered LNG gas to meet domestic consumer demand, demonstrating the flexibility of LNG at a time of increased demand. In-depth research by DOE in 2015 found that exports are a net benefit to the U.S. economy. The DOE study determined that increased production will drive investment to revitalize economically depressed regions of the U.S. and bring thousands of jobs to those areas. In fact, the September 2017 study by ICF showed that exports could generate more than 450,000 jobs and more than $73 billion for the economy by 2035. LNG exports do more than just provide jobs and investment. They offer an opportunity for also strengthening America's foreign policy interests abroad. LNG exports are already supporting our national security interests by strengthening the energy security and weakening those nations who look to use natural gas for political leverage. So in conclusion, the promise of more LNG facilities in the United States brings a promise of a new era benefiting U.S. economy and our global allies. Our enormous natural gas resource base ideally positions the U.S. to compete on a global level for the market share. Free and open trade of U.S. LNG sends the important signal of unencumbered exports to the market. Artificially limiting LNG exports could undermine commitments to free and open markets, as well as lead to complaints in international trade cases in the future. In closing, we commend Representative Johnson for his leadership and steadfastness in championing LNG over the course of the last several years. His legislation would ensure that consistency in the review process without sacrificing the rigor and thoroughness of our review. I thank you for your time today and look forward to answering your questions.
Thank you. Thanks all for your testimony. Since I was a little late coming back, we'll start with Mr. Olson for questions.
I thank the chairman. And again, welcome to our 5 panelists. My first question is for you, Mr. Riedel. As you heard in the first panel, I was pretty strong about LNG exports, that they are a national security matter for our country. Can you talk about, we mentioned some countries like Lithuania, Poland, South Korea, India, Japan. Can can you talk about some countries like that or other countries that where our gas has been shipped, can be shipped, and about what upcoming projects might we send overseas? How can we expand that market?
Happy to answer that question, and thank you for it. So a couple of things. You touched on some of the countries that we're already sending gas to. To date, we've got one facility operating in the lower 48 that's exporting natural gas, a second that's going to come online very soon. That single project that's exporting right now out of the U.S. Sabine Pass Cheniers project has exported to over 25 countries. That's expected to continue to increase, and I think that as you continue to see additional cargoes of LNG moving into Europe, as they start to see the reliability of U.S. LNG coming there, other countries are going to look to come online. Germany just opened an LNG import facility in the port of Hamburg. So I would expect there's another opportunity for U.S. LNG to start being delivered to Germany. But I think the other areas is that we didn't talk about is in South America. In Latin America, there are enormous opportunities there that we haven't necessarily fully exploited yet.
And do you agree, if we don't export our LNG and don't sell it overseas, that market will be swamped by other countries, other entities that will drop the ball, let them control these nations or have influence with them that we should grab right now? Can we do that? And you confirm that that's a benefit of exporting our liquefied natural gas?
Absolutely. Yeah, the time frame, as I had said in my testimony, is limited for this opportunity for U.S. LNG. You think about the length of time that contracts are typically signed, 15 to 20-year length contracts. So right now, countries are looking to purchase LNG, and if we don't capitalize on it, there are other exporting countries that absolutely will.
I was on a trip with Chairman Upton and Chairman Walden to Asia a couple years ago. We went to Japan, China, and South Korea. All those nations, especially Japan and South Korea, were just craving our exports of our oil and natural gas. They are tired of being strung out by Russia and OPEC. They want that freedom, that independence. And right now we can do that. Thank you. My final question for you is kind of want to make you, I'm not going to ask you guys, do you like the Houston Astros to be in the world champs, but have a player named Jose Altuve, MVP of the American League. Little man, about 5'5" tall, but a great power hitter. I'll make you Jose Altuve. I'm going to throw a big fat pitch right down the middle if you knock out of the park. My question is, what are some of the benefits to a state like my state of Texas from increased exports of LNG? Cream that pitch.
Happy to. There's a couple. One is obviously the job creation that comes along with it here domestically. The other major opportunity that I would point to is the obvious is the geopolitical impact. You mentioned some of those countries that are craving U.S. LNG. The third is the environmental impact that we could have in helping other countries meet some of their environmental standards. And you look to a country like China, for instance, in Beijing, last quarter, they reported a 54% reduction in CO2 emissions. Greenpeace actually reported that. So you start to see the impact of switching from other fuels to natural gas and the environmental impacts that would happen there. So those are the three that I would point to.
And obviously, John's back home. A little town called Beasley, Texas, has this company there called Hudson Products. They make the compressor blades for these LNG ones that Cheniers to be passed. Those top of those trains, you see that they probably sold 5,000 units and more are coming. So that's big for Texas. Small little towns thriving because of our export liquefied natural gas. My final question is for you, Vice Chairman Kavula. We're in a very different world than we were when PURPA was passed, long time ago. And as you know, as I mentioned, my state, #1 wind power in America. In fact, it's a fast-growing job sector in our state. And there have been hours the past year where wind has supplied over 50% of our statewide power, 50%. If we make changes to PURPA, do you think it would change the investment decision to keep building wind turbines in a state like mine?
Vice Chairman Olson, no, I do not. I think renewables have been deployed throughout the country in response to price signals that clear through open markets and competitive solicitations issued by individual utilities and overseen by state commissions. And if you look at my testimony, you'll see that that's how the vast majority of renewables are being brought online, in contrast to renewables that come to state commissions and litigate in front of them asking for us to play crystal ball reader about what future market prices are.
Thank you. I yield back.
Mr. Rush.
I want to thank you, Mr. Chairman. Mr. Ciccio, As you may have heard during the first panel, I asked both representatives from FERC and DOE if they had any concerns with hastily approving LNG exports and the impact that might have on domestic natural gas consumers, manufacturing competitiveness, and American jobs. Were you satisfied with their answers?
Thank you for that question. No, not at all. You know, we have examined all of the DOE studies that were that were completed to justify the approval of non-free trade agreement LNG exports. And we find them woefully inadequate to establish whether or not it's in the benefit of the country and satisfies the public interest. Where we are today is that a total of, you know, around 53, 54 BCF a day of LNG exports for free trade and non-free trade have been given final approval. That's 70% of U.S. demand in 2016. Shipping that volume cannot possibly be in the public interest. So we are unsatisfied with that. We think that they have not fulfilled the Natural Gas Act and the regulatory responsibility to protect the consumer long term. This is not a short-term concern. This is a long-term, but we are making decisions today as to whether these terminals get approved and then will be built later on. So this is why we have to be careful not to overcommit legally on approving these applications today for the future demand that will happen.
Certainly want to thank you. Mr. Romano, in your testimony, you note that H.R. 4476 would grant utilities full control to determine the size of their competitors' market. Additionally, under this bill, a utility could refuse to purchase energy or capacity from a qualified small power facility. If the utility unilaterally determined that it has no need for the energy or capacity in a IRP process, why is this problematic, and what impact might this provision have? Who would be responsible for oversight under this section of the bill as it is currently drafted?
Thank you, Ranking Member Rush, for that question. In order to answer it, we have to understand that there's IRPs and then there's IRPs. We have only 40 states in this country, as I believe, or roughly 40 states in this country that even have IRPs. The level of regulatory oversight by state commissions of those IRPs varies dramatically. The time period that those IRPs are meant to address varies dramatically. And the authority of the regulators to actually dig into the details of these integrated resource plans varies dramatically. In some places, basically, the utility puts together their set of assumptions, their set of evaluations about resource needs, and then basically sends it over to the commission. And the commission may or may not even have authority to read it, much less question it or approve it. So what we're really doing is saying that in a planning process, which isn't even focused on procurement under Section 4A and B in the proposed bill, that a utility can use that to definitively exclude a competitive offer of energy without any real regulatory oversight. And as you heard earlier on, even FERC is unsure the extent to which they have any authority to look at the use of these IRP type decisions as a subterfuge for basically undermining competition. My concern, therefore, is that Section 4A and B essentially puts the utility in the driver's seat, and a lot more qualifying facilities will be denied access to markets as a result.
Mr. Johnson.
Thank you, Mr. Chairman. Mr. Riedel, thank you for your kind words. We have been working for a long time on the LNG issue and the ability to put America into the LNG markets globally. You know, my district in eastern and southeastern Ohio that sit on top of the Utica and the Marcellus Shale is no stranger to the economic benefits of the shale energy boom and the vast amount of gas at our disposal. With the Sabine Pass facility already exporting LNG and with more export facilities under construction, new job opportunities have simultaneously emerged in my district, a part of the country that has been impoverished over a number of years. As pipeline infrastructure is laid, combined cycle power plants are being built, while ethane crackers and ethane storage possibilities begin to take shape or are already under construction. In many cases, local budgets of counties and townships have also been saved from oil and gas tax revenues that have increased their coffers. In fact, the top 6 shale counties in my district have collected more than $43.7 million in real estate property taxes from 2010 to 2015. That's a lot of money for Appalachia. The median income within those counties has also risen over a similar period. So, Mr. Riedel, the Appalachian region has clearly benefited from the use of natural gas in various ways. Do you expect this trend to continue as more export facilities come online?
I think the short answer is absolutely, we do. We would expect that. I think if you look at sort of the number of jobs that oil and gas industry already supports, 10.3 million jobs. If you look at where we're projected to go, we've got, like I said, 1 facility operational, 1 set to become operational very soon, and another 4 that are under construction. I would expect that there would be somewhere in the neighborhood of 10 facilities operational in the next 5 to 7 years. And if you look at sort of the amount of opportunity that those facilities represent, roughly 10 BCF a day projection of exports, it only is going to mean that there is more opportunity for those states that are producing the gas and need to then get those gas to the facilities to have opportunities for additional demand. And as I mentioned in my testimony, it's all new production that is going to meet that demand from these LNG facilities, which means additional jobs because there's going to be additional rigs running. And that ripple effect on down the line in the support roles or support opportunities, the jobs that would come out of that as well, is one that you can obviously becomes a multiplier pretty quickly.
Okay, well, thank you. Facing competition from other countries, and we know there's competition out there, I understand, as you mentioned, that our window of opportunity to export LNG is limited. What's a realistic outlook for global LNG demand over the next 20 years? And what does that outlook mean for companies wishing to build LNG export facilities here in the U.S.?
I think that answer, you look at sort of the current demand today, roughly 35 BCF a day is the current demand. There are projections that would show that doubling in the next 20 years. And if you look at sort of where we're at from a production of LNG globally, we're expected to start having a shortfall pretty quickly with coming demand in the mid-20s, depending upon which academic study you would look at. But what that means is the opportunity for U.S. natural gas and LNG exports in particular, those long-term contracts that are going to start popping up here in the next few years, U.S. LNG is going to be competing on a global level for those contracts. And so if we look at potential doubling of LNG demand in the next 20 years, our opportunity to look at some of the projects that are currently waiting approval, we don't have a lot of time to wait before they're going to need to start making investment decisions to build those facilities to meet that coming demand.
Do you think there's going to be any market pressure to allow only so many LNG facilities to be built?
Sure. So if you look at the projections of where total demand are, how contracts are already set up with other countries that are exporting LNG, EIA projects that out through 2050, roughly 12 BCF of LNG exports, which account for a much smaller percentage of our overall production of close to 40 BCF. So absolutely, the market is going to limit how much export we'll be able to capitalize on.
Okay. One final question, and you know, different experts give different opinions of this, but what is your realistic projection of what our U.S. natural gas supplies are? What do you think?
Well, I think that it depends upon, EIA is typically where I would point to as far as the potential opportunity, and that number that I continue to hear is somewhere in the neighborhood of 2 to 3 TCF.
Okay, Mr. Chairman, I yield back. Thank you.
Mr. Green.
Thank you, Mr. Chairman, and I don't know if y'all were here earlier. I'm kind of torn because I'm from Texas, but I also have an area that has chemical plants, and we've seen just huge number of expansion of those plants in East Harris County and along the Texas Gulf Coast. My colleague from Texas knows that we have some ice cream in Texas, that Bluebell Ice Cream, and their slogan is that we eat all we can and we sell the rest. That's where I come from. I want to be able to use that for relatively small, cheaper utilities so we can bring manufacturing even more in, but also for, in our area, my manufacturing is refineries and chemical plants. And I don't mind selling the rest. I just don't want to make sure we can still continue the growth in our area. Mr. Rydell, can you talk a little bit about how the LNG market's evolving from a potential market with facilities waiting for approval, and what are we learning now? We're finally up and running some of those facilities.
Yeah, great question. And I appreciate the opportunity to share some thoughts on that. I think the big thing that we continue to focus on is the long-term opportunity for LNG. And when we look at it here in the United States, so I was talking with Congressman Johnson's question, we're still talking about an excess of gas. So we're meeting all of our needs for gas. EIA projects that we're going to meet all of our needs for gas in the future as well. We're going to have a surplus of gas. And when you look at what EIA projects, dry gas production increasing year over year for the next few years, what that gives us is an opportunity, looking out to 2019, even, we're talking about 5.5 BCF a day of exports. And so when we talk about a total production number and close to 80 BCF a day, we've got an enormous opportunity to still capitalize and room to grow, as mentioned in the first panel.
Okay. This a question I have is, and for the entire panel, how big is our natural gas supply in the U.S. looking in that crystal ball in the future? Can we support both a huge domestic demand as coal plants continue to close and a large LNG export footprint? Why don't we start at this end of the table? Do you think those projections where we can have our ice cream and eat and sell it too?
Putting me on the spot, but since PURPA's my MO, but I will say in eastern Montana, western North Dakota, we've still had a big problem with flaring natural gas because we can't make productive use of it coming off of the oil patch. So there seems to be a clear surplus.
I'll respond. I go through South Texas a lot, and there's still a lot of flaring in Eagle Ford that if I was a royalty owner there, I would be upset about that because you're putting that product into the air that we could sell to somebody. Mr. Sparks?
Yeah, part of my responsibility at Consumers Energy is fuel for generation, which includes natural gas, and everything that I've seen shows that there is an abundance of natural gas going forward. And I would say that probably the limiting thing more is pipeline capacity to get it from the production to facilities than it is the actual natural gas itself.
And a comment too, I know West Virginia and Ohio have trouble getting those pipelines up to the Northeast where they really do need the natural gas.
This is not my field of expertise, but living in the Northeast and looking at the reliability assessments that are produced by NERC for our region, I would share Mr. Sparks' statement that up there, our issue is transport. We don't make a lot of it directly there. We're concerned about the pipes. And from Texas, you'll remember once upon a time when Mr. Wyatt realized that at a certain price, it's cheaper to send lawyers down the pipeline than gas.
Having known Oscar Wyatt for most of my life, I understand.
The only independent source of how much natural resources we have is EIA, and we have used their AEO 2017 demand to 2050, 33 years away. And when we look at domestic consumption, LNG exports that they have forecasted, and pipeline exports that they have forecasted to Mexico on a net basis, so it's fair, it consumes 56% of all of our lower 48 natural gas technically recoverable resources. Technically recoverable does not mean that it's economically recoverable. So 56%. If we put in that scenario, and it's in my testimony, that we can assume that that all that has been approved is in that 33 years, you use up 80% of all the natural gas resources.
Mr. Rydell.
So I think that I would say the short answer is yes, we can. We are not necessarily supply constrained. We are demand constrained. That is, we are needing to find markets for this gas, which is why we're talking about LNG exports, which is why 10 years ago we were talking about imports and now talking about exports, because we've found so much gas.
Yeah. Mr. Chairman, thank you. I have a concern, though, we got a crystal ball, because when we put something in the law and take away oversight, I would be more concerned, not maybe a hard hand of oversight, but somebody minding the store to make sure that we're not raising our utility cost or having, because I remember when the price of natural gas in the North Sea was cheaper than it was from Louisiana and Texas, and we lost chemical jobs over to Rotterdam. And I don't want to get to that point. So that's why I think the bill we need to look at to see somebody can go in, whether it be Department of Energy, and say, you know, this is a national security issue. So, Mr. Chairman, I thank you for the time.
Mr. Flores.
Thank you, Mr. Chairman. I want to share my friend from Texas on the other side that is a former member of the oil and gas business for years. We've got plenty to eat what we want and sell the rest. So for decades, if not centuries. Let's talk about PURPA first, if we can. Mr. Gavella, you heard from your neighbor there at the table that the impact that these PURPA contracts are having on their company. My local community is powered by a muni, and so we've got smaller electricity utilities out there, munis, co-ops, and so forth. What's the impact on those folks? They don't have a shareholder base, if you will, to spread the economic damage of these PURPA contracts over. What happens to the munis and the co-ops?
In my view, the smaller the consumer base of the utility, the greater the potential magnitude of erroneous price forecasting from the regulator would be. In the case of a municipality, they are likely, I assume in Texas, self-regulated by their city council. These are people who are probably even in less of a good position than I am to try to guess about the future market prices of energy for the purpose of establishing a rate that should be paid.
Let's kind of cut right to the chase. Who gets hurt?
The consumers.
Exactly. Yeah. There we go. Okay. And I'm sorry, I wasn't trying to cut you off. I've just got some other things that we need to talk about. Mr. Riedel, I appreciate your testimony today, and I've been fascinated by your neighbor at the table and some of the things he said. And as you know, somebody who's an expert in this field, I do have a good feel for the supply of natural gas in this country and the huge impact it's had not only on our economy, but also geopolitically. How do you respond to his claim that our energy abundance is a myth?
It's a great question, and I appreciate the opportunity to talk a little bit about that. I think that there are a couple points that I would point to. One, if you look at Congressman Johnson stepped away, but the state of Ohio alone in 2016 added 5 TCF of natural gas proven reserves. And so I think that there's some miscommunication here or mix up here in what we're talking about with proved reserves and technically recoverable reserves, and how the market will actually dictate, demand will dictate how we recover those reserves.
Exactly.
And at what price point we recover them. So when we talk about a supply situation, it's driven by market demand. And so as market demand continues to increase, we're able to respond to that with supply. And we've seen it happen time and time again since the discovery of the shale gas in the early 2000s.
Well, the other thing that's fascinating, too, is that technology continues to change the paradigm, and it's happening at an incredibly rapid rate. If you could have told me you'd get oil and gas out of some things we're getting out of today, if you'd have told me that 15 years ago, I would have thought you were smoking some bad dope, but it's really interesting. I guess I got to be careful with my record here, don't I? The oil and gas, you know, I want to talk about the impact on jobs and the economy a little bit. The oil and gas industry was one of the bright spots at a time when our labor markets were struggling, and particularly if you look at the 2008, 2016 time period. There were some times during that time period, if we hadn't had the increase in oil and gas jobs, that job growth would have been negative. And so it's been a hugely positive factor for economic opportunity for what I would consider working class Americans in this country. Stable jobs, great incomes, great benefits. And so I want to drill in on a more of a micro basis. So how many jobs are typically created by the construction first, and then the operation of an LNG facility?
So construction, and if you look at the sort of time frame of a construction project, one of the fastest moving projects that we've got going right now is the Cove Point project, which is set to begin operation, and that's somewhere in the neighborhood of 40 months of construction time. And that creates somewhere between the neighborhood of 4,000 to 7,000 jobs at each one of these facilities. And so if you talk about we're building 4 more, you can pretty quickly do the math on how many long construction jobs that supports over a number of years. And then if you think about sort of from an operational standpoint directly at a facility, it's not an enormous number of jobs, but we're still talking about adding real wages and real jobs to each one of those facilities in the neighborhood of a few thousand employees for each one of those facilities.
Okay, and those jobs are not paid in crumbs, right? They're paid in
No,
good.
No, average
jobs.
salary is well over 6 figures in those jobs.
Okay, that's well, 6 figures, right?
Yes, sir.
Okay, great. Thank you, Mr. Chairman. I yield back.
Gentleman is back. The chair now calls upon the pastor, Mr. Wahlberg from Michigan, for 5 minutes. Correct.
Thank you, my son.
Amen.
Go Cubs. Thank you to each of the panel for being here. And in relationship to PURPA, our design is to make sure that the consumer is benefited. And we are certainly open. We are open to discussing better ways of doing things. But in the end, we want the consumer to be king and have utilities that can succeed in such a way to make the consumer king. So I appreciate you being here today. And Mr. Sparks, before I get to my questions, I want to thank you for being here. I'm greatly appreciative of what CMS does in my district, being headquartered there, and all of the impact, and the fact that, we've talked about a lot of things, and it's an absolute truth that you're ahead of the curve and ahead of the game of even what our state is mandating as far as renewables, and you're leading the way on those things, and it comes not because you're being forced, but it's a better way when it works, and so I appreciate that. You gave your comments early on, and I'm sure you've listened as other things have been said. So I want to give, before I ask my questions, an opportunity for you to comment on any things that you heard, and I'd like to add to the mix here.
Yeah, thank you, Mr. Wahlberg, for that. 2 things I would say. One is, at least for Michigan anyway, Michigan has got a very robust integrated RIP process. We've been going through stakeholder meetings over the last year. We're now having public meetings to talk about the whole process of integrated resource planning. All of the utilities in Michigan have to file integrated resource plans by, I believe it's April of 2019. Our company will be filing one before June of 2018. So I would just say that lots of opportunity for all stakeholders to participate in that process in Michigan. The other thing I think I would just mention is that I believe that HR 4476 actually promotes competition. I don't understand how forcing customers to buy from renewable resources that are priced higher than other renewable opportunities or other generation resources for that matter could ever promote competition. So by lowering that threshold, in my view, it actually promotes competition.
Well, add to that a bit. One of my questions was going to be, is it fair to say that consumers' energy is being forced to purchase power they don't need at above market prices?
Absolutely. Our company right now has 650 megawatts of wind resources that we either own or we contract for. We just brought online 44 megawatts of wind this past December, $45 per megawatt hour. We just, another third party that we contract with brought on 100 megawatts of wind this past November, less than $45 per megawatt hour that our customers are paying. So when we look at the avoided costs that have been established for consumers' energy for renewables, it's much higher than that, sometimes twice the cost of what I just quoted. And we have plans to put more megawatts from wind on our system, again in that mid $40 range. So,
drilling down a little bit further, if HR 4476 were signed into law, would it save your customers money? And if not, what will they overpay?
It absolutely would save our customers money, dollar for dollar. Our power supply costs are a direct pass-through to our customers, so any dollar that we can save in power supply costs will go directly to our customers. In my opening remarks, I commented about customers paying about $35 million, we predict, more than what they otherwise would pay from other options from all of the PURPA contracts that we've been asked to sign. That was as of last week when I was preparing my materials. I looked yesterday, we're up to about $53 million now.
Finally, I understand Consumers is taking steps to expand your renewable generation portfolio, as you've mentioned. This is an effort I applaud, but want to know if PURPA is actually hindering consumers from building more renewable generation at lower cost to your customers.
It certainly could in the future if enough PURPA generators come onto our system. We obviously have to look at that supply-demand balance, and we wouldn't want to have more generation available than what our constituents, our customers, would consume, so it could affect that, yes.
Mr. Chairman, without objection, I'd like to submit letters from 17 different entities in support of this for the record.
Without objection, so ordered.
Thank you. I yield back.
The gentleman is back. It appears that we have no further members seeking us some questions. So on behalf of the entire subcommittee, thank you for your patience. I want to remind you all, all members have 10 days to submit questions for the record, legislative days, and our guests have 10 days to respond to those questions after receiving them. Before we close, I'd like to enter 21 letters for the record. A letter from Alliant Energy, a letter from American Public Power Association, a letter from the Arizona Power Service, a letter from the Bays Electric Power, a letter from Berkshire Hathaway Energy, a letter from Consumers Energy, a letter from Covanta, a letter from DTE Energy, a letter from Duke Energy, a letter from Edison Electric Institute, a letter from the Electricity Consumers Resource Council, woo boy, a letter from the Environmental Law Policy Center and Natural Resources Defense Council, Solar Energy Industries Association, Southern Environmental Law Center, and Vote Solar, all collectively. A letter from the Idaho Power Corporation, a letter from the Independent Power Producers Coalition of Michigan, a letter from the Industrial Energy Consumers of America, a letter from ITC Holdings Corporation, a letter from National Association of Regulatory Utility Commissioners, a letter from the National Rural Electric Cooperative Association, a letter from OG Electrical Corporation, a letter from Portland General Electric Company, a letter from Excel Energy. Without objection, so ordered. Again, thank you. This hearing is adjourned.